Petition allowed.
Sir, back to mention.
Lordship, this matter may kindly come up for admission, Lordship. The parties are represented.
Item number
1.
What has happened, there was a condonation of delay in this application, which was allowed. Then the matter had come up in the orders column on the last occasion. It was fixed in the, all parties were represented on that day, 1 to 6. Respondent 1 to 6. Then it was fixed for motion.
heard, miss.
Lordship,
Your name, please.
F. Ahmed.
F. Ahmed, learned counsel for the petitioner, and Mr.
P. Sengupta for 1 and 2.
Learned counsel for the respondent number 1 and 2. The learned counsel for the petitioner submits that the matter may be listed for admission hearing. Fair allowed, recess list the matter. After
Bihu.
After Bihu. Okay.
Deeply appreciated.
Lordship, my senior leaks in another court, Lordship. May pass over the matter for time being, Lordship. Highly observed.
May the Lordship. By the instant the revision petition, we are aggrieved the impugn order 23/12/25, wherein Milord, the plaintiff Milord, on a similar ground Milord, earlier occasion Milord, the petition preferred by the plaintiff legal heirs under Order 1 Rule 10 Milord, wherein we approached this court that after legal heirs, plaintiff died Milord, suit is already abated. The only remedy Milord, Order 20 Rule 31 Milord, and also we raised the Milord, Order 22 Rule 9(2), there is a provision Milord. That's why, and this honorable court has recorded all this fact, and they have also admitted that yes, certain they have not, the learned trial court has not followed the CPC provisions Milord. Despite the direction of this honorable court, my lord, overlooking the provision, again, my lord, same omission has been done, my lord. Kindly have a look at the honorable court's direction earlier, my lord, at page 48. Page 48 from paragraph 4, my lord. Thereafter, the present respondent filed the application under Order 1 Rule 10, read with 151 CPC, for implementing the legal heirs, namely the present respondent as substituted plaintiff in place of deceased plaintiff. Thereafter, it appears that the impugn order to change the application of the respondent was allowed by the trial court, and both the respondents were allowed to be substituted as plaintiff in place of deceased plaintiff, namely Sunil Das. The learned counsel for the petition submitted that the trial court was wrong in allowing the petition, as the petition was not filed under proper provision of law. The petition ought to have been filed under Order 22 Rule 31 of the Court of Procedure. However, the respondent have filed the petition under a wrong provision. It is also submitted that the learned counsel for the petitioner that the trial court was wrong in observing in spite of repeated opportunity given to the opposite parties. However, no objection was filed by neither the petitioner objected at the time of hearing. The learned counsel for the petitioner submits that the trial court made a wrong observation, as apparently on so and so the petitioner had filed a written objection objecting to the implementation of the respondents. He also submits that a copy of the objection filed by the petitioner was also received by the learned counsel and respondent side. He also submits that the petition for substitution.
Mr. Decker.
Paragraph 8 is the main important, my lord.
Paragraph
8. They have admitted that on the other hand, the learned counsel for the respondent has submitted that apparently the application for substituting the legal heirs of the deceased plaintiff appears to have been filed under wrong provision. Already they have admission on the part of respondent, my lord. Since the plaintiff died, my lord, suit is abated, my lord, only remedy, my lord, Order 22 Rule 31 and thereafter Order 22 Rule 92. But here, my lord, the learned trial court overlooking this provision of CPC, my lord, allowed on Order 1 Rule 10 petition, my lord. It's just implement petition. Until and unless to rectify the legal provisions of law, my lord, after death of plaintiff, the substitution is the only remedy as per this CPC provisions. But learned court again committed the same wrong despite this court good reactions, my lord. So we are before this court right now, my lord. Impugn order at page, my lord, page 53, Annexure 8. No whisper about the no discussion about our objection as well as the Order 22 is concerned here, my lord. Simply implemented. No delay, petition filed by the plaintiffs, legal heirs. So, my lord, the absolutely wrong procedure may submit, my lord. And since already, my lord, division bench of the Honorable High Courts, my lord, already supported my case, my lord. then the since after expiry of the plaintiff, my lord, only remedy order 22 petition rule 3.1, but not under order 1 rule 10, my lord. So I'd like to place this order, my lord. Instead of keeping this matter pending, applying the correct provisions of law, lordship may directed to
No, whether for quoting, misquoting or wrong quoting of any provision of law
my lord.
would render the order passed by the learned trial court invalid?
I couldn't get, my lord. Can leave.
No, whether misquoting or wrong quoting of the provision of law in the order
My lord.
by the learned trial court will invalidate the order?
No, my lord. Since admittedly, my
The
lord,
question is whether the court has the power
uh,
to pass such an order or not.
but as per the procedures, my lord, it demands, my lord, after expiry of the plaintiff, my lord, only remedy since suit is awaited, my lord, only order 20 rule 3.1 petition is maintainable, my lord.
No, you tell me whether implement will be required or not for deciding
My
the
lord, since they are the only,
deciding the
my
suit.
lord, yes, definitely, but they are the only legal heirs after plaintiff's expiry, my
then-
lord. So, since there is a provisions of law substitution, my lord, suit is already abated, my lord.
Mm.
Then after abatement, my lord, the procedure is clear, my lord, that substitution petition you have to file under order 20 rule 3, not under order 1 rule 3, order 1 rule 10, my lord. Clear, my lord, as this is law, my lord. And this my submission also recorded by the learned trial appreciated on this point. Same wrong has been done again, my lord, since non considering the petition, allowing the petition order 1 rule 10 instead of order 22 rule 3.1 as well as order 22 rule 9.2.
No, that petition was filed under order 1 rule 10 of the CPC.
Yes, just implement, my lord. After suit abatement, but it is procedures not permit this. Procedures permits, my lord. After abatement, my lord, only remedy, my lord, order 22 rule. Lordship, I need to read the provision of the CPC, my lord. Order 22 rule 3.1, my lord. The procedure in case of death of one of the several plaintiff or sole plaintiff, 1, my lord, where one of the two or more plaintiffs dies and right to sue does not survive to the surviving plaintiff or plaintiff
Mr.
alone,
Deka,
my lord.
there are several decisions of the Supreme Court that misquoting or wrong quoting of any provision will not invalidate any order if the court has the power to pass such an order,
My lord.
to grant such a relief.
Trial court, my lord.
Yes.
My lord, I respectfully submit, my lord, since only earlier occasions, since same application was allowed, my lord, order 1 rule 10, we approached before this court, and this honorable court has recorded all our findings, even admission on the part of respondent.
You see, thereafter
provision
also
applying,
the
my lord.
petition was filed under order 1 rule 10.
Rule 10, that petition is, my lord, at page, my lord, page 33, my lord. Page 33, can you have a look? What ground, my lord? This is the application. Page 33, my lord. Simply a petition of implementation, my lord. And this fact has been admitted by the respondent on the last earlier litigation, my lord, that it is a wrong provision of law. They have preferred this application. They themselves admitted this fact, my lord. Despite this, my lord, court again allowed their this petition. And our objection is at page 36, my lord.
You produced that judgment of the Supreme Court where it is stated that misquoting or wrong quoting of provisions will not invalidate the order if the court has the power to grant such a relief.
Lordship, may I
Where is
have
one
the question, my lord? The side is it?
Not now, at 2 p.m. At 2 p.m.
My lord, that is judgment, my lord.
No, it is old judgment.
I see.
May I please, Lordship? Lordship, here I am the defendant number 1 in the suit, Lordship. I
Pardon?
am the defendant number 1 in the suit, Lordship. And after my evidence was closed, Lordship, then at the argument stage, I have filed a petition, Lordship, because some witnesses were left out, Lordship, and required to be called. So I filed a petition through the advocate, Lordship. That petition was rejected. Under 151, I have filed the petition, Lordship, through my advocate.
You come to paragraph number 7 of the impugn order.
Yes, Lordship.
So how many adjournments you have availed?
Adjournments have been taken, Lordship.
Granted.
Some adjournments have been taken. It is an admitted, Lordship. But for the ends of justice, Lordship,
End of justice. No, whether
He
there
was
is any
bedridden.
provision in the CPC
he was bedridden for
to
he days.
allow you for indefinite period to grant adjournment
Not for indefinite
to
period, Lordship.
place
One chance.
for
Sought for one
adjournment,
chance, Lordship. He sought for one chance only.
one chance,
Yes.
one chance.
He has taken evidence on 6/1/25. The
Hmm.
evidence was closed, Lordship. And on 8/7, that petition was filed.
Hmm. The evidence was closed for the plaintiffs on 14/2/2023.
Was closed, and the next date was fixed
Yes.
on deed for DW.
Next date was fixed on 10/4/2024 DW.
For DW.
And on 6/1/2025,
DW evidence.
evidence of DW closed. And the case was fixed for argument.
Yes, Lordship.
Thereafter, the petition was filed,
Yes, Lordship. On 8/7.
8/7. Hmm.
One more thing, Lordship. This person, he met with an accident, Lordship, and he
evidence
was
was closed on
almost
6 of
bedridden for
2025.
about 3 years, Lordship. He was bedridden for almost 3 years, Lordship. That is mentioned in paragraph 4 also of the order, Lordship. And moreover, Lordship, he is an injured person, Lordship. No, around
Whether
76
you have enclosed the petition here?
that petition, Lordship.
Yes.
Yes.
Page number?
Translated portion is, Lordship, at page 80 from 87, Lordship.
80?
7.
'89 is the vernacular.
Yes, Lordship.
So what reason you have assigned in this petition? For failing to examine the witnesses earlier?
Petition, Lordship, it is it's only one paragraph 3. He was bedridden for 3 years. That ground is there. And apart from that, Lordship,
Bedridden for 3 years from who is that to who is that?
that is not mentioned, Lordship. That is not mentioned.
That is not there. So what is the justified reason for granting you another sons? That too after closing of the evidence and while the case is pending at the stage of argument.
What you have sought for is for the calling the official witness, Lordship, because there's a dispute with the sale deed, Lordship.
That's all right. I am asking you the reason why you could not call the witnesses earlier. Why you failed to file the application earlier? And due to lack of reason, the trial court has dismissed your application. How this impugn order is illegal and arbitrary? You demonstrate before this court.
That reasons are not there, but even, Lordship, that
Then
his illness was one of the ground, Lordship.
for illness, you have mentioned nothing in the petition. Since who is that to who is that you were bedridden? What wrong with the impugn order? We dismiss the petition.
May please, Your Honor.
Hmm.
And the defendant in the main suit, the impugn order is at page 91.
Whether for filing the counterclaim subsequently you have obtained leave of the court?
I filed a petition for leave. Hello. What happened in this case, my lord? We have filed our written statement. Thereafter, the case was fixed for its document and issue. Thereafter, we have filed a petition for amendment of the written statement, which was allowed.
Hmm.
After that, we have filed that order is at page 36. May I have gone through the petition and considered the mode of amendment sought. By way of amendment, the defendant side has sought to add some para and para in context of his pleadings of the written statement. By adding the new abutment, the defendant side sought to raise the point of non-joint of necessary improper court fee and about suppression of some material facts in the plain. Besides, through the amendment, the petitioner side has sought to add some material facts which were necessary for determination of real controversy. The proposed amendment will not affect the right of the opposite party and will not change the nature of the suit. And since the amendment sought on the written statement, as in this case, bring any new cause of action, it is also found that the issues have not yet been settled. In view of this, the petition was allowed.
Okay,
According-
where is your application seeking leave of the court to file the counterclaim? Is number
At page number 81.
81.
1. Against which they have filed their objection
Hmm.
and kindly please page number 95 of the order.
Pardon?
Page number 95 of the order.
Yes.
The defendant have certainly the right to file the counterclaim. It is also necessary to avoid multiplicity of the suit. But the time of filing the counterclaim and the way of filing the counterclaim in the pretext of filing additional written statement cannot be accepted. Because I have filed the counterclaim along with the amended written statement. But before framing of issues.
No, that's all right. The principle is that for filing counterclaims belatedly, you have to obtain leave of the court.
That is true. I have filed an application for accepting my counterclaim along with the written statement.
Okay. We allow the petition.
Please, Lordship. In this case, plaintiff's evidence is closed, Lordship. What happened, Lordship? After framing of issue, PW evidence of PW 1 and 2 were filed. They were cross-examined and discharged. Thereafter, evidence of PW plaintiff and another witness was filed, and 1 or 2 adjournment was taken. Thereafter, Lordship may come page 39. On that day, they were present. The order dated 25/7/2025. On that day, they were present, but they could not be examined. Next day was fixed on 18/9/2025.
Where is the impugned order here?
Lordship, last page, page 45.
How many adjournments you have availed?
Earlier, 1 or 2 adjournment was taken, but PW1 and PW2 were examined, cross-examined and discharged. Plaintiff's evidence and another witness. Now, previous adjournment cannot be considered while considering a new adjournment. Because earlier it was genuine, that's why it was allowed. Only condition which has to be seen that whether the present adjournment sort was genuine or not. For this day, on adjournment was sought on the ground of illness. Lordship.
No,
And-
no. In CPC, how many adjournments you
adjournment.
want to take that has been
Order 7 and 3 adjournments.
prescribed?
Lordship. In that,
3 adjournment,
yes, but this is not mandatory.
mandatory.
This is not mandatory.
Mm.
It can be, there are decisions
Mm.
which says it can be, may I please?
You produce before this court a record on how many occasion you have availed
Oh.
adjournment.
That was previously.
Yes.
On that ground, Lordship, I am submitting on that previous adjournment.
No,
cannot be considered.
you first produce before this court a record, how many adjournments you have
These are
availed.
not their previous. But I am admitting that previously few adjournments were taken. Yes.
Okay, we list it on some other day. You produce the record.
Lordship.
Heard Mr. Purkesto, learned counsel for the petitioner. Mr. Gogoi for respondent number,
2 and 3, Lordship.
respondent number 2 and 3. In this petition under Article 227 of the Constitution of India, the petitioner has challenged the order dated 27/11/2025, passed by the learned civil judge junior division number 2, Kasar Silsor, in title suit number 57 of 2015. It is to be noted here that by the impugned order dated so and so, the learned trial court has dismissed the application filed by the plaintiff. No, dismiss the application number 1215 of 2007. No, struck 07. Rejected the petition number so and so. For granting adjournment. Mr. Purkesto, to a pointed query of this court submits that earlier the petitioner has availed some adjournments. But he could not say as to how many adjournments the petitioner herein have availed during the course of the trial. Accordingly, it is provided that Mr. Purkesto, learned counsel for the petitioner, shall produce the particulars of the adjournments he has availed earlier in this suit. List the matter on
2 weeks, Lordship, 2 weeks.
after 2 weeks.
Date.
27
27
months.
months. Obliged.
Well, through this petition, I am making a simple prayer, my lord. There is an execution case, my lord, petition pending before the learned executing court since 1999. And even after several petitions and objections raised by the respondent.
You are for the decree holder.
Yes, my lord, I am for the decree holder. Various petitions and objections filed by the respondent in the form of 47, 2197s were dismissed. And thereafter, Najir has taken over the charge. Well, on various occasions, Najir wanted to visit the suit land, but they did not visit. And then lastly, my lord, they visited the suit land, but came up with a report, my lord, which is apparently favoring us. And now they are trying to challenge the decree passed by the, my lord, honorable court, my lord. If I may take your lordship to the Najir's report.
Page number?
Page number, your lordship will find at page 154.
Yes.
Yes, I may not read the preceding paragraph.
Yes,
or
only the relevant paragraph.
Yes, from moreover, my lord,
Page number 2.
Page number 154, it starts with the word moreover. Second
Yes.
last paragraph. madam.
Yes.
Moreover, in the warrant to give possession of scheduled land in connection with title execution case number 14 of 1999, it appears that when compared said warrant with decree in connection with this case and main execution petition, that is title execution number 14 of 1999, and earlier warrant, there is a mistake in schedule A, B, and C. That in schedule A of the present warrant, the eastern boundary is recorded as Kajal Bhattacharjee, alias Pradeep Bhattacharjee, and the western boundary as Ran Chandra Sharma, now his son Jogendra Sharma. However, in the decree, the main execution petition and the earlier one, and the eastern boundary is recorded only as Kajal Bhattacharjee, and the western boundary is Ramchandra Sharma. Well, Kajal Bhattacharjee and the Pradeep Bhattacharjee in the preceding line I have read, they are same person. It is written, that's why Kajal Bhattacharjee alias Pradeep Bhattacharjee. Now their objection is, in the schedule B of the present warrant of instant case, there is recorded as one house, thatched house, being the house bounded on south by the illegal permanent construction made by the defendant, and on north Sahadev Gosai, east Kajal Bhattacharjee, south road west Ramchandra Sharma, standing on the land measuring 6 lectures, covered by new DAG number 1795 or PP number 685 of Tejpur town, third part Moja, Mahabharab district, Sonitpur, and schedule is bounded as south road east Kajal Bhattacharjee alias Pradeep Bhattacharjee, west Ramchandra Sharma, now his son Jogendra Sharma. However, in the decree, main execution petition and the earlier issued warrant, there is only one thatched house, being the house bounded on south by the illegal permanent construction made by the defendant, and south side road standing on the said DAG, and PP is not mentioned. And in boundary of east, there is only Kajal Bhattacharjee and western Ramchandra Sharma. Though it is very specific, Kajal Bhattacharjee.
The question is, in spite of this discrepancy, whether the land in question is identified.
Yes, my lord, and that's what determined by the learned courts below, my lord, both in the order 21/97 petition as well as the appeal filed by the third party. If I may take your lordship to the relevant portion of the order, page 41 is the order. It is the order passed in Midje case number 155 of 2014 in a petition filed under order 21 rule 97, filed by a third party, my lord, Lal Babu Shah. When the relevant portion,
what is the finding here?
73, page 73. Paragraph 21, my lord. May I read, my lord?
Yes.
At this point, I would like to bring some light upon the survey commissioner report, which is the petitioner side has exhibited as exhibit 18. The survey commissioner Atkin Brothers had surveyed the land to find that the petitioner has been occupying a portion of land covered under DAG number 1795. 2358 new. The petitioner had approached the Honorable Gauhati High Court regarding the report of the survey commissioner, and the Honorable Gauhati High Court, by its order dated 2/6/2014, which the petitioner has exhibited as exhibit 19, had given the liberty to this court to consider the report at the time of judgment, and in the same order, the Honorable Court had directed the court to consider the petition filed by the petitioner under section 47 of the CPC in accordance with law provided under order 21 rule 97/98/101 of CPC. Thereafter, the petitioner had filed this instant petition afresh with new facts and surmises upon which the Midje case at hand has been registered. Clearly, the Honorable Gauhati High Court had not allowed the petitioner to file a new petition with new facts, but the direction was to consider the petition under Midje case number 138/2009. It is apposite to mention here that the opposite party decree holder has fought a long battle for the attainment of finality of the decree, which is under execution. The decree was passed back in the year 1999, and it attained finality in the year 2009. After going through series of appeals and revisions, thereafter the objector had filed another petition under section 47 CPC, which was registered as Midje case number so-and-so, which was again withdrawn, and this instant petition was filed claiming certain relief, such as declaration that the land on which the objector has possession is not a part of the decretal land.
No. Oh, what is the ultimate finding of
Ultimate finding, my lord, in the below, my lord, below portion paragraph, in the same page, 74. Further, amongst other, the rule mentioned herein above also clearly shows that the petition filed under order 21 rule 97/99/101 of CPC is not maintainable, as the facts of the case falls under the ambit of disqualification mandated under Rule 101 CPC. My lord, here the third party who is possessing the decreted land has claimed before the court, my lord, learned executing court, that the land which is under his possession is not the decreted land. There the court has given a finding that the land which forms the decreted land is in the possession of the, my lord, third party. And that's why under this background, order 21 rule 97 petition was dismissed. And in the next issue, 75, point for determination whether the objector petitioner is in possession of the decreted land. The Lordship may skip page 75. We may start from paragraph 25, page 76. As discussed earlier, the petitioner in his evidence categorically has mentioned that he has claim over the decreted land, though he has stated that he is presently possessing a plot of land covered under DAG number 1792. The PW1 has strained upon the point that he has valid right over the plot of land covered by DAG number 1792, and he is not in possession of the decreted land, which according to him is unidentifiable. And then, my lord, it is needless to, my lord, it was his submission that the decreted land is not identifiable. It is needless to reiterate that an executing court cannot go behind the decree. However, it has already been decided in the concerned TS number so-and-so that the defendant in the suit, Dhanpal Gwala, could not prove his case as being the adopted son of Malu Gwala. Hence, he has no right over the property purchased by Malu Gwala. Accordingly, the present objector cannot derive any right over the property sold by said Dhanpal Gwala or his legal heirs. Moreover, the title list relied upon by the objector is of the year 2005 and 2012. That means the sale deeds were executed when the matter was still sub judice. Accordingly, the petition is also hit by the disqualification mentioned under Rule 102 of Order 21 and 27. However, the moot question remains as to whether the objector is in possession of the decreted land. And as discussed earlier, the PW1 himself stated that he is possessing a part of the decreted land covered under DAG number 1795 by way of occupying two rooms, one for a mobile phone shop and another for residence purpose. Further, going by the Survey Commissioner's report, which is available on record, being a part of the Midje case number so-and-so, withdrawn by the objector, it is abundantly clear that the objector has been possessing a chunk of decreted land, that is land covered under DAG number 1795. But that was the finding of the learned court, my lord, executing court. They preferred an appeal. Appeal was also dismissed. Now, somewhere or other, my lord, the Nazirs and the revenue staffs are, my lord, involved in the execution, and they are somehow, my lord, not reluctant to, my lord, dispose or dismantle the structure, my lord, of the third party. The third party is in possession, and through the judgment debtor, he is filing petitions one after another, my lord. As many as 5 civil revision petitions were, my lord, earlier preferred before this honorable court. All revision petitions were dismissed by this honorable court. Now the report also, my lord, if we, my lord,
Nazir report.
yes, if we read the report even, here also, my lord, your lordship will find the report is somehow vague. Here the first objection is that in the, my lord, page 154, first objection, in the warrant, it is written Kajal Bhattacharjee alias Pradip Bhattacharjee, whereas in the decree, it is written only Kajal Bhattacharjee. The man was standing there when the Rajir visited the place. He explained them that he is my brother, Kajal Bhattacharjee alias Pradip Bhattacharjee, same person. Well, his objection is why only Kajal Bhattacharjee is written? Why not alias Pradip Bhattacharjee? His only objection. And the third objection, my lord, 155, in Schedule C, starts with second paragraph. In Schedule C of the present warrant of instant case, bounded as South Road, house in occupation of defendant, East Kajal Bhattacharjee, West Ramchandra. However, the northern boundary is completely missing. When the three boundaries are, my lord, identifiable, the fourth boundary comes automatically. These are the vague, my lord, objections and the reports they are filing.
Now, what is your prayer?
I am just praying that when a direction may be given to the learned executing court, my lord, to considering the, my lord, history of this case, to dispose of the execution case, my lord, within a time-bound manner. It is fixed on 28th of this month, because, my lord, I am aggrieved by an order passed by the learned executing court in the last page, 156, where I prayed for cross-examining the bailiff. There, the court is of the opinion, my lord, that I should, my lord, a chance should be given to the other side to object to the petition. which is not within the ambit of order 26 rule 10, where he says when a report, commissioner report is submitted, it will be part of the record and either party has the right to cross-examine. But the right is initiated from the code of civil procedure. Right of objection is not there. What they will do now, they will linger the process. This is my apprehension. A direction, simple direction may be given to considering the history of the case to dispose of the execution petition within a time bound manner, within a month of 1 month. They are litigating since more than 20 years. Only 6 lectures of land they purchased in the year 1996. Since then, they are not in possession of the land. And various petitions were filed, objections 47, order 21. Those petitions were dismissed, and the cost was also imposed by this honorable court in various civil division petitions. And then also somewhere or other, and Najis report also, a bare perusal also the report shows that the report is also vague. There is no question of not identifying the land. Land is identifiable. His objection is that only alias is not written. Earlier it was written Kajal Bhattacharjee alias Pradeep Bhattacharjee. Now it is written Kajal Bhattacharjee. Alias means with another name of the same person.
Okay.
19.
So the citation, do you have the citation of this Periamal case?
My lord.
Do you have the citation of the Periamal case?
Yes, my lord.
You furnish it to the court.
2025 9 SSC.
Furnish. We'll pass the order.
Yes, my lord.
May I please, your lordship?
Yeah.
My lord, I filed a petition under section 12(1)(a) of the Hindu Marriage Act for nullity of marriage, lordships. The case is pending since 2018, and I subsequently filed a application under Order 6, Rule 17 for amendment of my petition. The trial court, family court rejected my petition, holding that this is a separate cause of action. My lord, kindly see the page 32 of my petition.
No. Your first ground is
First ground is initial petition,
initial petition
12
for
1
declaring the
for a decree of nullity of marriage.
nullity, and
Lost.
secondly, you have you want to amend the petition
For
by
inserting,
incorporating the decree of divorce, pair for decree of divorce.
lost it, for inserting that section.
Is it permissible?
Permissible, lordship.
How?
Because lordship,
Whether this amendment will not change the nature and
Even-
character of the suit?
case is pending, and the case is pending since 2018. And even after within 2 years,
No.
after 2 years,
You,
there
Mr.
is
Bormoya.
more than 6 years. And second thing is
No, Mr. Bormoya,
Yeah, lordship.
you
Yes, lordship.
answer the question of this.
whether it is a separate cause of action.
Yes,
Both section 12 and 13, both end marriage terminate lawsuits with the parties. Even Supreme Court says, even a separate cause of action, the second, when the second suit is permitted to file, why pending suit with the parties should not be permitted? So, to avoid the multiplicity of may I place the judgment of the Supreme Court lawsuit? And kindly say, court held that it is I am shifting that ground. That is not I am inserting. The 12 is there. And second, paragraph 17, 18 lawsuits. May I read lawsuits? Court lawsuit, paragraph 17, page 393 show about. In our view, since the cause of action arose during the pendency of the suit, proposed amendment ought to have been granted because the basic structure of the suit has not been changed and there was merely changed the nature of relief claimed. We fail to understand if it is permissible for appellants to file an independent suit by the same relief, why the same relief which could be paid for in the new suit cannot be permitted to be included in the pending suit. As discussed above, the real controversy test is the basic or cardinal test, and it is the primary duty of the court to decide whether such an amendment is necessary to decide the real dispute with the party. If it is, the amendment will be allowed. If it is not, the amendment will be refused. On the contrary, the learned judge of the High Court, without deciding whether such an amendment is necessary, have expressed certain opinions and entered into discussion on the merits of the amendment. In cases like this, the court should also take notice of subsequent events in order to shorten the litigation, to preserve and safeguard the rights of both the parties, and to subserve the ends of justice. It is settled by canon of decision of this court that rule of amendment is essentially a rule of justice, equity, and good conscience, and the power of amendment should be exercised in larger interest of doing full and complete justice to the party before the court. Lordship clearly says, lordships, and the courts, I am inserting, and even trial court said, I am shifting that ground. And both grounds, lordships, nullity of marriage, judiciary decree to terminate the marriage between the parties.
At what is this, the suit is pending?
Lo-
At what is this, the suit is pending?
Lordships,
At what is this, the suit is pending?
should argument stage,
Argument is this.
lordships.
So is it permissible at the argument stage?
Even, sir, lordships, permissible at any stage,
At any stage?
at any stage, order says, rule 76,
At any stage?
at any stage.
Okay. Have you gone through the proviso to the order 6 rule 17?
That trial,
Due diligence.
lordship, if trial commence, even the Supreme Court in this were said, but here in the instance said, trial court, the family court not said that this trial has been commenced. Even in case of trial,
No,
even
no,
with,
here it is in the last stage, argument stage.
yes, orders 6 rule 17, page 2, like proviso, lordship. But here in the imperial not say that it is a trial commence. Only says separate cause of
No,
it.
no, forget about it. It is in the stage of argument.
Argument at any,
Can it
even
be said that trial has not
today,
commenced?
lordship, today I have not
You come to proviso.
proviso. Provided that no application for amendment shall be allowed after trial has been commenced unless the court comes to the conclusion that in spite of due diligence, the party could not have raised the matter before the commencement of the trial.
Where is the due diligence in your case?
That demanding provision I also stated
Where?
in my petition. See,
No, no, in the application filed before the trial court, where you have mentioned,
lordship,
where is that petition?
that petition is at page, lordships, page 27.
27. In which paragraph you have explained
Last
your due diligence? So you have not gone through the petition.
Lordship, paragraph 3,
Yeah.
4,
Paragraph 3 and 4.
lordships. And the diligence is also, and paragraph 6, lordships, that the petition itself explain the delay and demonstrate that the amendment is crucial for the instant case. Page 30, paragraph 6. Crucial, say, and it is a fact not introducing a new time but cause of action or prejudicing the wife, that is respondent unfairly, and in this stage, the honorable court have discretion to allow the amendment, the interest justice and outcome depend on the specific circumstance and court discretion and
No, no,
application
that is,
emphasis
that is
diagnostic
the
and due
inconvenience
diligence
you will suffer, you have mentioned there.
17.
But what is the reason for delay?
Reason lawsuit, wife has not, I waiting for whether she will file any competition or the restriction of conjugal life or any application filed before
No,
the
where you have mentioned it?
lawsuit. That paragraph 3 lawsuit, that during the pendency of the instant case, the right after 2 months the marriage and both the parties of the present case have been living, staying separately and the respondent has willfully and without any reason left the house of the petitioner, that is husband, and no case was filed by the respondent except source of criminal case which is pending before this honorable court, and also stated by the respondent herself that her prosecution and she had not filed any complaint before any law enforcement agency regarding the demand as well as non-cooperation in the marital life of the petitioner, even though she have not filed any case for restriction of conjugal rights against the petitioner, that the both the parties have been staying separately till to date above than 6 years, and no petition or any claim by the respondent of the instant case stated in petition for the restrictions as well as others, and it's a fact that the respondent herself willfully deserted the petitioner, and in this stage for the above said genuine ground, it fulfills elements reserved as a ground of seeking divorce as the instant case. The petitioner have filed the instant case for the aforesaid reason as stated above, and both the parties are living separately for above than 6 years. So record of the instant case, and there is no chance of reconciliation between the above said parties of the instant one and the aforesaid matter as well as genuine ground.
Sir Borvia, that is the explanation for filing the suit.
Lordships. Court tribunal held that because it is a separate cause of action. Tribunal not that I have not, why not file? That order not reflected, the findings is not in the IPN order. It is delayed, that's why. Finding is that this is a separate cause of action.
Maybe, are you not supposed to explain the delay?
Lordship says,
Hmm?
in spite of these lordships,
In spite of?
in spite of, I am waiting for since I filed a petition.
Hmm.
It will be immediately disposed
No,
of.
is
But
that the ground?
this way and that way it has been delayed.
Is
And
that the
even that
ground?
paragraph 6 lordships,
Paragraph 6 is a reason for
paragraph
filing the suit.
7 lordship that appear. Then paragraph 7 and 8 lordship can see, page 30. The petitioner has filed this petition with a hope for the consideration as well as for proper justice for the above said genuine ground from the honorable court, and in this regard, the petitioner of the instant case will deposit the amount regularly in favor of the respondent for the interim maintenance related the instant one as per as order of the honorable court. And the petitioner of the instant case always honored the honorable court, and the respondent has filed only the FC case number sons of before the court,
There
which
is
is
no
fixed for
explanation
DW.
for delay.
And the respondent also expressed in her examination chief and also stated address that the respondent has been staying in her paternal house for last more than 5 years, 6 years, would not challenge all the allegations of respondents in any way that was stated by the petitioner in the petition related to instant case. And other respondent, after knowing as well as the filing of the instant case, does not file any case complaint before the authority, honorable court, other than the opposite case stated as above, which is genuine. Court held that only because
Hmm?
this is a separate cause of action. Even
Maybe.
separate cause of action.
Even then, are you not supposed to explain the delay? Mhm. You come prepared at 2 p.m.
Here also, my lord, a decree has not been prepared, so we filed a petition under section 152. And the
For?
for my lord, preparation of a decree in terms of the, my lord, the grounds we have mentioned, my lord. In fact, my lord, the facts in nutshell is that, my lord, we filed a suit for, my lord, we constructed a gate, my lord, in the name of my father, my lord. We inscribed the name of my father in a marble plated, my lord, on the wall, my lord. And that, my lord, affixation was destroyed, or, my lord, we can say, my lord, demolished by the authority. So we filed a suit initially for compensation. In the compensation suit, my lord, they filed a counterclaim, we withdrawn the compensation suit. Then we filed a suit, my lord, for allowing us to affixing the name of my father, my lord, on the wall of the school. That suit was decreed, but somehow we are not satisfied with the judgment and decree rendered in the suit, my lord. If I may take your lordship to page 16, it is the suit, my lord, of 1 of 2007, and the page 16, and the final order, the lordship will find at page 25.
No, you are not satisfied with the
We
judgment
filed an
and decree.
appeal.
That is a different matter. But this is a major case in which the trial court has passed the order, and this order is impugned in this petition.
Yes, we filed a petition under section 152, my lord.
For
Because
correction of the decree.
there's a little history in this case, my lord. We filed my lord, two separate appeals, my lord. One before this honorable court and one before the, my lord, first appellate court in the, my lord, district court.
Let us do one thing. Let notice go at this business. Heard, Mr. Biswas, learned counsel for the petition. This petition under Article 227 of the Constitution of India. The petitioner has challenged the order dated 13/2/2026, passed by the learned district judge Lakhimpur in major case number 03 of 2020, whereby the petition filed under section 152 read with section 151 of the Code of Civil Procedure for correction, clarification of the accidental or clerical omission in the judgment and decree dated 7/1/2026, passed in title appeal number 1 of 2008, and for drawing up separate and proper decree has been rejected. Where is the petition and the documents placed on record?
Petition, your lordship will find at page
Let-
35.
And also peruse the order dated 13/2/2026, passed by the learned district judge in major case number 03 of 2020. That notice be issued to the respondent, returnable in 4 weeks. Stayed by speed post and also by usual process within a week from today. List after 4 weeks. If you are not satisfied with the decree. you
No,
can,
we are not, we are satisfied with the decree. We are satisfied with the decree. We challenge the judgment and decree in two appeals.
No, just a few minutes back you have submitted that.
Well,
somehow you are
earlier,
not-
we are not satisfied. We filed an appeal before this honorable court. After the change in the pecuniary jurisdiction, that RFA was sent back to the learned district judge court, where one more appeal was pending. So one notice was issued to club these appeals together and pass a common judgment and decree. And while doing so, my lord, one appeal judgment was, my lord, grounds were considered, and those, my lord, grounds were heard. And the RFA's, my lord, grounds which were sent back by this honorable court due to, my lord, change in pecuniary jurisdiction, those, my lord, observation and the were not considered, my lord, those grounds. And though the appeal is allowed in my favor, but the decree is not prepared. And if the decree is not prepared, my lord, the executing court is saying, my lord, what to execute now. Because our prayer was to affix the name of my father on the wall. And that was allowed. But there is no decree prepared. If I may take your lordship, the decree portion only said it is allowed and appeal is allowed, page 81. Page 82 is the claim for from the judgment and order dated 31/3/2008 passed in title cert number so and so. This appeal is coming up on the 7th day of January 2026 for final disposal before me, so and so. In the result, appeal is allowed. The impugned judgment and order passed by the learned civil judge Lakhimpur is liable to be set aside. But this is the decree. A decree has to specify as per in terms of order 20, rule 6, it has to specify the reliefs granted by the court, my lord. And that's why I was praying your lordship may dispose it of with the direction in consonance with order 20, rule 6 to prepare a decree. Issuing notice, my lord, they will come and appear. It will otherwise, my lord, will lengthen the, my lord, matter.
No, the case has already been disposed of.
Yes, disposed of,
So-
but decree is not prepared, my lord. For this reason, my lord, we have filed a 152 petition. Your lordship is very much aware, my lord. Decree, there are judgments also, my lord. 152 petition, my lord, has to be considered when my lord, there is a mistakes in the decree or decree is not prepared. Order 20, rule 6, my lord, of the Code of Civil Procedure is very clear. Decree has to specify what are the reliefs granted. It doesn't specify anything. This is only my humble prayer. Your Lordship may dispose it of with a direction to the learned court, my lord, to consider this, my lord, in view of Order 20, Rule 6, and lay down the decree, my lord. This is my humble prayer. We are satisfied with the decree. We have no problem with the decree. But since there is no executable decree, my lord, there is nothing to execute. I think the confusion was arisen because of clubbing these two appeals, my lord, and taking one common hearing, my lord, as per the direction of this honorable court and subsequently issuance of notice by the learned district judge, my lord. Order to.
No, is the decree drawn up by the appellate court is common decree?
Common decree, my lord. If I may take your lordship to page 61, this was the direction. 61. This was the order dated 2/4/2024. The appeal number 1 of 2008 has been received by this court via Honorable Gauhati High Court memo number so and so, which was transferred to the Honorable Gauhati High Court in connection with transfer petition number so and so via order dated so and so. The original case record of RFA number 28 of 2008, which was pending here, which was filed by Sri Mantosh Majumdar and two other appellants, has also been received as the pecuniary jurisdiction of district judge was enhanced to rupees 20 lakhs. So and so, along with the record of title appeal, RFA number so and so and miscase number so and so has been received. Peruse the case record of RFA number so and so and the title appeal number 1 of 2008, which were arose from the title suit number 9 of 2007. Both appeal were filed by Sri Mantosh Majumdar and two others against the judgment and order decree passed by learned civil judge, Lakhimpur, North Lakhimpur, dated so and so, and against the same appeal, which was registered as title appeal number so and so before so and so. As both the appeal, RFA number so and so of Gauhati High Court and title appeal number so and so has arisen out of same judgment, order and decree dated so and so, both the appeal will be tried together. In view of this order, my lord, both the appeals were tried together, heard together, and disposed of together.
No, whether the parties in both the appeal
Same.
same, whether the pair, no, whether the judgment impugned in both the appeal are same.
Same, my lord, more or less same, my lord. In this second suit, my lord, which was withdrawn by us, they filed a counterclaim. After withdrawal my suit, my lord, the counterclaim proceeded. In the counterclaim, the judgment and decree was passed, and that too in my favor. The first judgment, your lordship will find page 16. Operative portion, your lordship will find page 25. The title suit number 1 of 2007. This was this first suit. Page 16 is the starting of the judgment, and 25 is the finding, my lord. The suit of the plaintiff is decreed, allowing him to affix the marble plate on the gate and allowed to write inscribe on it gate renovated. My lord, we want donated, not gate renovated. That's why, my lord, we filed an appeal challenging this portion of the, my lord, judgment. And the second judgment and decree, wherein they filed a counterclaim, this is, my lord, at page 30.
Whether planes of both the suits are available here.
My lord,
Whether the planes
same, my
both the suits are available here.
yes, my lord. Planes are not available. We have annexed the judgment and decree, my lord. Considering my lord, voluminous of
No, we'll
document.
see the pair portion of the planes in both the
My lord,
suits.
one, my lord, I have a certified copy of the 1 of 2007.
The other one, 9 of 2007, that is not available.
This is the counterclaim filed by them in this suit, my lord. 1 of 2007. This is the prayer. And this was the counterclaim filed by them. We withdrawn the suit, but the counterclaim proceeded and the judgment and decree passed in counterclaim. And that too in my favor.
You do one thing, then you produce the plaint of the other case.
Yes, my lord. A week later, my lord. A week later,
Modify that word. Should notice or for a Mr. Business Learned Counsel for the petitioner submits that title appeal number, oh no, by no, in title appeal number 1 of 2008, two suits being title suit number 1 of 2007 and title suit number 9 of 2007 have been disposed of. And he has the certified copy of the plaint of title suit number 1 of 2007, but the other, but the plaint of other title suit number 9 of 2007 is not available with him. Then he prays for granting him 1 week time to bring on record the plaints of both the titles suit by way of an affidavit. They are allowed. Recessal is the matter after a week. You take back this. So file an affidavit.
much obliged.
Serving attendant 2.
May please, your lordship. The petitioner was the defendant in the trial court, your lordship. After that, the expiry judgment order passed against the petitioner, your lordship. But due to fault,
But Mr. Islam,
lordship,
whether appeal will lie or revision will lie.
to check up, if not check up,
You
the
see,
file.
by the impugned order, your appeal was also dismissed
Appeal initiated.
while refusing to condone the delay.
Lordship. But this is
So
against-
when your appeal is dismissed, then whether appeal will lie, second appeal will lie, or revision will lie.
check up, fix another date.
On the pair being made by Mr. Islam Learned Counsel for the petitioner. Rest is the matter after a week.
Next week, any
Sure.
date? Next week, any date? please.
Next week,
23rd March.
3rd March.
No, please.
4 orders. Number 18 and 19. What matter?
My lord, in this case, lordship, as per Wazima Court, lordship, regarding service of respondent number 3 and 4 already completed, lordship. Kindly peruse the order dated 023/2026 of the Wazima Court's order.
Lordship, I'm appearing for respondent number 4.
Respondent number
4, UGC.
Order is lordship 2/3/26, 2nd March, lordship, of Wazima Court, lordship.
who does the
I have a copy of that, lordship. It should be. I have a copy of that, lordship.
oh, we do. Okay.
It will be there. I can obtain the copy of the order, lordship. So I pray, lordship, this matter, since it is a part-heard matter, lordship asked for taking steps, me pleading them as a party. I pray, lordship, since service is completed, I pray let the matter may be listed in the last week of March. Little bit urgency, your lordship has already heard the matter, lordship.
Last week of March would be too early because I have just entered appearance today. Today is already the 11th of March.
You are for the UGC.
At least 4 weeks time.
You are for the UGC.
UGC. I need at least 4 weeks time to file my affidavit in opposition.
Heard Mr. Bhuya, learned.
Lordship, I pray for fixed date, Lordship.
No, heard Mr. K. Mazumdar, learned counsel for the petitioner.
Lords, there is a
And
second
Miss-
prayer.
P. Agoral, learned standing counsel for the UGC. Being respondent number,
On number 4.
respondent number
Four.
4.
Pre-ICT, Lordship. Copy has already been served, Lordship. Service already completed.
Mr. Mazumdar, referring to the order dated 2nd of March 2026, passed by the Lozima Court, submits that in this petition, service has already been completed, and as such, the matter may be listed for admission. Pair allowed recessal is the matter in the first week of April.
Lordship, a fixed date may be subject to convenience.
Lordship, if it could be on the 10th of April, Lordship.
It may be on 9th, Lordship. It's a hearing day.
Hearing day, Lordship,
Because on Friday,
don't know
Lordship,
whether I will be able to file my affidavit by then or not, Lordship.
No, you try to file your affidavit.
it's a simple matter, Lordship,
Matter is there.
as part heard, Lordship,
Okay, 9th.
Lordship,
as part heard.
may be directed to serve me with a copy of all the IAs that they have filed. They have only sent the copy of the writ petition.
Only in the writ petition, their stand is there. In the IA, if it's for impleading or other.
Thing is there before the honorable court, and I am a party to that particular case. I
Lordship,
am entitled to. a
No,
copy
in
of
the-
it.
only in the main writ petition while heard the matter, Lordship, not in IA, Lordship. So Lordship asked me to implead them as party. If necessary, Lordship, without lingering the matter, since the matter has already been heard for NOC of the government is necessary not on that part, Lordship, and some judgment, 3 judgments on that count of your Lordships on this or in this subject. So while hearing the matter of the government, Lordship, the Lordship was pleased to ask me to take
No,
steps.
that's all right. You furnish the copy to.
Lordship, please, I'll serve the copy.
In the
No
meantime,
need to
Mr.
mention the order, I'll
Monitor
serve the
learned
copy.
counsel for
Within
the
3 days,
petitioner
Lordship,
shall
3 to 4
furnish
days.
a copy of the writ petition and also copy of the IA.
There, Lordship.
Writ petition already, sir.
Okay.
Only the IAs.
Copies of the
Copies
IA, I'll serve the
interlocutory
copies.
application to Ms. Agarwala during the course of the day. Today
Lordship,
itself.
it may be tomorrow, Lordship. It needs photostat, everything.
Okay,
Lordship.
within 1 week from today.
Lordship, please.
Lordship, date
9th
9.
of April.
9.
Obliged, Lordship.
Item number 20.
Yes.
Although office note dated 6/3/2026, Lordship reveals that Lordship, the answer brought is in respect of respondent number 1 has returned back, Lordship. And we were supposed to take a step upon respondent number 2 and 3. Lordship, if your Lordship go through the office note dated 26/11/2021, notice have been served upon the respondent number 2 and 3, Lordship. I flag mark, there is a green flag mark, Lordship. In respect of respondent number 2 and 3, notice have been served upon them, Lordship. Now we are required to take first step upon only respondent number 1, Lordship.
Respondent number 1. Heard Mr. Halder learned counsel for the petitioner. No, for the appellant. Mr. Halder referring to the office note dated 6/3/2026 submits that notice issued to the respondent number 1 returned with a report addressing not available or returned to the sender. And he submits that he may be allowed to take fresh step upon respondent number 1. They are allowed step be taken by speed post and also by usual process within a week from today. Further, referring to the office note dated 26/11/2021, Mr. Halder submits that in view of the aforementioned office note, notice upon respondent number 2 and 3 have duly been served. And as such, he is not required to take any step upon the respondent number 2 and 3. As observed in the office note dated 6/3/2026. Recessal links the matter after 4 weeks.
Obliged.
21. appearing on behalf of respondents number 166, Your Lordship.
Hmm.
But as can be seen from the office note, respondent number 7, the notice has not been served, but she is mother of some of the respondents, Your Lordship. So we need some time to take instruction on as to whether the.
Okay. None appears for the appellant on call. However, Mr.
A Mishra on behalf of S.
A. Misra, learned counsel, appearing on behalf of Mr.
S. Nawaz.
S. Nawaz, learned counsel for the respondent number 126. So Misra submits that he may be granted some time to obtain instruction in respect of respondent number 7, who happens to be the mother of some of the respondents. We are allowed to recessal is the matter after 2 weeks.
A date may be fixed, Your Lordship. A date may be fixed. Substitute.
In the event of subsequent non-representation of the appellant, appropriate order shall follow.
22.
None appears for the applicant on call is the matter after a week. In the event of subsequent non-representation of the applicant, appropriate order shall follow.
23.
May I please, Your Lordship? I'd like to withdraw this petition, Your Lordship.
Withdraw.
Yes, Your Lordship. As
Heard,
regards
Mr. Your
A.
name?
Hussain, Your Lordship.
A. Hussain,
Yes, Your Lordship.
learned counsel for the petitioner. So Hussain submits that he has the instruction to withdraw this petition. Accordingly, this petition is disposed of on withdrawal.
All right.
24.
My lord, may kindly peruse the last two orders where the respondents have not appeared. However, my lord, this is a transfer petition of 2024. Transfer of a case for restitution of conjugal right filed by the husband before Kamruk.
Hmm.
And I am the wife. I reside at Borpeta, my lord. My lord, the grounds are at paragraph 15, 16, 17, my lord. First ground is that during the, my lord, marriage, physical torture was there, for which she alone cannot come to Gauhati. And she do not have her mother or father, my lord. Only one brother is there. So alone she cannot come to Gauhati from Borpeta. My lord, second ground is that the distance of 141 kilometers are there. And after filing of this transfer petition, she filed one divorce petition and maintenance petition, which are still pending at Borpeta, my lord. So if
So in this petition before the family court.
filed by the husband for restitution of conjugal rights.
Okay.
So if this is transferred there, the three cases will continue, my lord,
Where?
to Borpeta, my lord. Because other two cases are still pending at Borpeta, my lord.
She has filed one petition for dissolution of the marriage and the other petition for
Maintenance, my lord.
maintenance.
Stephen was it? And Stephen case is also there. Just recovery of Stephen, my lord.
Heard, Mr. Dick and learned counsel for the petitioner. None appears for the respondent on call.
Our grounds are at
It
15.
appears that one counsel, namely Ms. J. Burman, N. Burman, Sri N. Burman and Ms. J. Burman entered appearance by filing Ukalatnama on Ukalatnama and also file an affidavit in opposition on 16/5/2025.
My lord.
Mr. Nath, learned counsel for the petitioner submits that this petition is pending since the year 2024, and as such, the same may be disposed of. Accordingly, taking note of the submission of Mr. Nath, learned counsel for the petitioner, it is proposed to dispose of this petition by this order. This petition under Section 24 of the Code of Civil Procedure is referred to the petitioner for transferring FC civil case number 950 of 2024 pending before the Court of Learned Principal Judge Family Court number 3, Kamrup M. at Gauhati, to the Court of Learned Principal Judge Family Court at Barpeta. Mr. Nath, learned counsel for the petitioner submits that the petitioner is the respondent in FC civil case number 950 of 2024, instituted by the respondent herein, who happens to be the husband of the petitioner for restitution of conjugal right under Section 9 of the Hindu Marriage Act 1955. Mr. Nath further submits that you are working at Barpeta.
No, my lord, I am studying. Right now, I am after separating from my husband, I am continuing my study at there, my lord. Husband is working at Gauhati, my lord.
Okay. Mr. Nath, learned counsel for the petitioner further submits that marriage between the petitioner and the respondent herein was solemnized on 20th to 2022, and thereafter they lived together as husband and wife in the matrimonial home at. Where is the matrimonial home?
Barpeta. And initially they were at Barpeta. Thereafter, my lord, for their service, they reside at Gauhati.
At Barpeta, and thereafter the petitioner, no, the respondent herein, who has been working in disaster management department,
My lord.
Gauhati, is transferred to Gauhati. And both of them shifted to Gauhati.
Initially, yes.
And initially, both of them shifted to Gauhati. And thereafter, marital discord surfaced between them, and the petitioner herein left the matrimonial home and used to reside at her parental abode at Barpeta. And in the meantime, the respondent herein has instituted the suit before the Principal Judge Family Court, Kamrup M. at Gauhati, being FC Civil Case number 950 of 2024 under Section 9 of the Hindu Marriage Act for restitution of the conjugal right. Mr. Nath further submits that the petitioner is pursuing her studies at Barpeta, and the distance between Barpeta and Gauhati is 141 kilometers, and it is not possible on her part to contest the aforementioned proceeding at Gauhati. And further, he submits that the petitioner herein has also instituted 2 other proceedings under Section 125 CRPC, and also for dissolution of the marriage before the district judge Barpeta,
Principal Judge Family Court.
Principal Judge Family Court at Barpeta. And whether he appeared there?
Yes. He is regularly appearing, my lord.
And in the said proceeding, the
That
respondent
evidence
herein
is now.
are regularly appearing. And as such, there is a requirement of transferring the aforementioned FC Civil Case number 950 of 2024 to the Court of Learned Principal Judge Family Court at Barpeta. Having heard the submission of learned counsel, For the petitioner, this court has carefully gone to the petition and the documents placed on record. And it appears that the respondent herein is working in Gauhati and is instituted the FC civil case number 950 of 2024 in the court of principal as family court at Gauhati. On the other hand, it also appears that the petitioner herein is pursuing his studies at Barbeta, which is located at a distance of 141 kilometers from Gauhati. And besides, two other cases are also pending in the court of principal judge family court at Gauhati. And taking note of all the facts and circumstances and also the submission of Mr. Nath, learned counsel for the petitioner, this petition stands allowed. FC civil case number 950 of 2024 pending before the court of learned principal judge family court at Gauhati stands transferred to the court of learned principal judge family court at Barbeta.
Obliged.
My lord, I'm sorry, my lord, I think no, that item 21, my lord. I was in another court, 21, my lord.
Okay, later on. Mr. Your name, please?
M. Setia.
M. Setia, learned counsel for the appellant and third appellants. You take the date from him.
Okay, my lord. Interim has to be continued, my lord. Interim was there, my lord. In IA.
Pardon?
In IA, my lord, interim was till today, my lord.
Interim order passed in the ISL continue.
My lord, 25 and 26 both are arising out of the analogous dispute, my lord. In 26, there is a delay, and we have also filed a condonation petition. So, my lord, condonation petition may be allowed, my lord, and then both the case may be heard and disposed of together.
Delay of how many days?
My lord, about 562 days.
562
days. My lord, the ground is that, my lord, by mistake, my lord, inadvertently filed appeal. The appeal is not entertained, it was returned. And therefore, my lord, delay has caused. My lord.
Any objection?
Like to submit that petition. They stated that the appeal was returned on 17/5/23. Even after returning, they filed the CRP on in the month of December 13/12. So the appeal was returned in the month of May. Until May to December, there is no explanation. Explanation is there. My lord, explanation. In paragraph 3 of my lord, explanation is there, my lord, because the one person has main person who was conducting the case, he expired, and other persons they are not residing in the locality, they are residing Siliguri, my lord. That was the problem, my lord. That we have explained.
Where?
My lord.
In which paragraph?
My lord, lordship may kindly have a look at paragraph 4. Paragraph 4 and 6 also. My lord. घूर सोली ये लास्ट 10 years का है नहीं ये इनका धूल मन
Mr. Mukherjee, have you gone through the applications? Application?
Now 4, 5, 6.
Not gone through the same. Okay, after some time, you go through it and you let this court know whether it has been explained or not.
Your lordship for the delay party.
Okay.
Otherwise, it is like they have prepared a appeal which was not maintainable.
Heard Mr. Sikdar, learned counsel for the applicant, Mr. Mukherjee for the respondent. This application under Section 5 of the Limitation Act is preferred by the applicant for condonation of delay of 562 days in filing filing the connected civil revision petition. Mr. Sigdar, learned counsel for the petitioner, no, applicant submits that initially the applicants have filed one appeal. Where you have filed the appeal?
My lord, you have filed the appeal. Appeal was 2022. My lord,
Title appeal number 1 of
title
2022 before.
It was filed, my lord. It was filed 2022 and it was returned by order dated 17/5/2023.
Before which court you have filed the appeal? Before the court of learned civil judge
Gwalpara.
Gwalpara. But subsequently the same was returned by order dated
17/5/2023.
17/5/2023.
3.
23. And thereafter, the applicant has filed a connected civil revision petition, and in the meantime, there occasion delay of 560 2 days, and that the delay, and that the aforementioned delay is not intentional, rather the same was circumstantial, and the same has been explained in the statement and averment made in the application, especially in paragraph number. In which paragraph you have explained it?
My lord, paragraph 4, 5 and 6, my lord.
4, 5 and 6. 4, 5 and 6. And that the civil revision petition may be, and that the delay may be condoned, and the civil revision petition may be admitted for hearing. Mr. Mukherjee, learned counsel for the opposite party, however, submits that he has no objection. Accordingly, taking note of the submission of the learned counsel for both the parties, and also considering the statement and averment made by the applicant in paragraph number 5, 4, 5 and 6, this court is of the view that the delay of 562 days in preparing the connected civil revision petition is sufficiently explained, and therefore this interlocutory application stands allowed. The delay of 562 days in preparing the civil revision petition stands condoned. In view of the order passed in this now the registry will proceed to register the CRP and place the same before the court as soon as practical. Next.
My develop it. Or 27. So 27.
And then the lordship has become infractional. The alia, the original suit has been dismissed.
Dismiss. Okay. Is it correct?
Yes, sir.
Heard, miss, your name please?
MRDV lordship.
M.R. Devi, learned counsel for the petitioner, and Mr. Mubarak for the respondent. Mr. Mubarak has produced one order dated 22nd of January 2026 entitled suit number 1 of 2023, and he submits that the original suit has been dismissed by the aforementioned order, and as such this civil revision petition become infructuous. The learned counsel for the petitioner also submits that the original suit has been dismissed. In that view of the matter, This CRPIO stands closed, being in process. The order produced before the court today shall be marked as Annexure A and be tagged with the record. Interim order passed earlier stands vacated.
May I please your lordship.
Lordship,
Respondents items.
Lordship, I voluntarily appeared to petition for having known about the case. Lordship, one place only, the copy may be.
I will serve it today.
Lordship.
My lord, in the meantime, I have a prayer, my lord. Some subsequent development has taken place.
Hmm.
Actually, the petitioner here in this petition, she has filed one application under section 144 BNSS before the principal judge family court, my lord.
Hmm.
I may be allowed to bring it onto the record as an additional affidavit.
No problem. Heard, Mr.
D. Bora, your lordship.
Learned counsel for the petitioner and Mr.
Yes, Hussain.
S.A. Hussain, learned counsel for the respondent. Petition has not been furnished to you.
I'll serve it today.
Okay, learned counsel for the respondent submits that he has not been furnished with a copy of the petition. The learned counsel for the petitioner undertakes to furnish a copy of the same during the course of the day.
With the course.
They are allowed. Let's list the matter on
My lord,
On or
after 3 weeks, my lord.
after 3 weeks.
Yes, my lord.
Okay, is there any interim order?
Interim order is there, my lord. That may
Okay,
be.
interim order pass earlier self-continuing. Mr. Bora also submits that the petitioner herein has also filed one application under section
144 BNSS, my lord.
144 BNSS before the Court of Learned Principal Judge Family Court, Barpeta,
Principal Judge Family Court, Kamrup Metro, my lord.
Kamrup Metro.
And the case number being FC criminal number 111-2026.
Being FC criminal number
111.
2026.
Yes, my lord.
2026. Then he may be permitted to bring on record the same by filing an additional affidavit. They are allowed. List the matter after 3 weeks.
Much of.
Yeah, please, your lord. Mr. Miller, I am appearing for a respondent, my lord. Since the while of the petitioner side, they have filed and filed the divorce petition for the honorable court and the file of the family court. And I'm appearing here, but I have let's not take the case from transport.
From where to where?
From Jorhat, my lord.
Jorhat.
District and Sessions Judge Jorhat
Okay. Okay.
to Principal Judge number 2, Family
Okay.
Court, Gauhati.
Heard, miss, your name, please?
M. Bora, Lordship.
M. Bora, learned counsel for the petitioner, and Mr. G.J. Soikia. U.J. Soikia, learned counsel for the respondent.
Mukame kumai thodi. Pale
This petition under section 24 of the Code of Civil Procedure is preferred by the petitioner for transferring Ms. G case number 10 of 2025 pending before the Court of Learned District Judge Surat to the Court of Learned Principal Judge number 2 Family Court at Gauhati. Ms. Bora, learned counsel for the petitioner submits that the petitioner is the wife of the respondent number 2. No, sorry, wife of the
sole respondent.
sole respondent who had instituted Ms. G case number 10 of 2025 before the Court of Learned District and Sessions Judge at Jorhat. But the present petitioner is residing at Gauhati.
Gauhati.
Residing in Gauhati, and on such count, it is not possible on her part to contest the aforementioned proceeding before the Court of Learned District Judge at Jorhat, and as such, the same may be transferred to the Court of Principal Judge number 2, Family Court at Gauhati, where another proceeding being
Civil 989 of 2025.
99 of 20,
989.
989 of 2025
5.
is pending. Mr. Soikia, learned counsel for the respondent. sole respondent submits that he has no objection since the petitioner herein has already instituted another proceeding before the Court of Learned Principles as number 2 Family Court at Gauhati. Accordingly, taking note of the submission of learned counsel for both the parties, this application stands allowed. Meiji case number 10 of 2025 pending before the Court of Learned District Judge Surat stands transferred to the Court of Learned Principal Judge Family Court number 2, Kamrup, Gauhati.
My lord, may I pray for a date for appeal here after 1 month or 45 days?
Okay, both the parties shall appear before the Court of Learned Principal Judge Family Court number 2 at Gauhati on
Because this day after tomorrow itself, so somewhere in April.
No, the problem is that the district judge Surat has to transmit the record to here.
Exactly, yeah.
After
The
a-
end of April, my lord.
Okay, after 4 weeks.
After 4
After
weeks.
4
Lord.
weeks.
Much.
Lordship, my senior is on legs. Kindly take up the matter after some time.
After?
Please, your lordship.
Okay, after some time then.
Yes.
31.
Lordship, as per office note, neither ID card nor unserved notice has been received till date. You may be allowed to take the first step along with justice service.
Justice service.
Yes, Lordship.
Heard, miss, your name please.
Okay, to me.
Learned counsel for the applicant. Office note dated 8/12/2025 indicates that neither ID card nor unserved notice issued to the respondent received by the section. The learned counsel for the petitioner submits that she may be permitted to effect service upon the respondent by disseminate where allowed. After effecting service upon the respondent by disseminate, the petitioner shall file an affidavit before this court. This is the matter after 2 weeks.
Lordship, kindly give us a long date.
Long date.
Yes, Lordship.
4 weeks.
30 April. Obliged, Lordship.
42.
Yeah, please, your lordship. I have for substitution, lordship. I have for substitution. Sole appellant was died, lordship. We have filed within time, lordship.
Okay, heard means that
Be ready, lordship.
learned counsel for the applicant. This application under order 22 rule 3 of the Code of Civil Procedure is preferred by the applicant for substitution of the legal heirs of sole appellant in the RSN number 56 of 2014. The learned counsel for the applicant submits that the sole appellant suffered demise on 17/7/2025, leaving behind as many as six legal heirs, and the said legal heirs are required to be pleaded in place of the appellant. In place of the appellant. And that the application is filed within time. And therefore he has contended to allow this application. But having heard the submission, learned counsel for the applicant and also considering the facts and circumstances it is on the record, this interlocutory application stands allowed. The legal heirs of the sole respondent, namely Srimati Gita Saha, Rita Saha, Ratna Rani Saha, Mithu Saha, Omi Saha, and Sunil Kumar Saha being pleaded as appellant number 1A, 1B, 1C, 1D, 1D, E, and 1F in the RSN number 56 of 2014. In terms of above, this interlocutory application stands allowed. In view of the order passed in this interlocutory application, the appellant shall file amended cost title within a period of 1 week or 2 week,
After 2
2 weeks. 2 weeks.
Wait, please, Your Lordship. Lordship, kindly peruse order dated 14/7/2025.
Yes.
By this order, Lordship, we have challenged the order of trial court, wherein interim order has been granted from the date of order. And the amount which has been granted against that, these two are our prayer before this honorable court. Now 14/7/2025, this honorable court directed the trial court to pass the order from the date of filing of the application as per Rajneesh versus Neha. And accordingly, Lordship, learned trial court filed order dated 19/7/2025. Order has been modified and directed the respondent to pay the maintenance amount from the date of application. So that prayer was, we have got the relief, but maintenance amount was pending. Respondent has not cleared the amount. Some part of amount has been given, but some part is till date pending. That is one of the prayer. And another prayer is, Lordship, the amount, quantum amount which has been granted to the wife and the minor child, 10,000, 7,000 for the wife and 3,000 for the minor child, who is now studying in faculty higher secondary school. Now, Lordship, the 10,000 rupees is not sufficient. That grievance is before this honorable court, Lordship. And the learned trial court in.
No, that is only the interim amount.
Yes, Lordship.
So your petition before the family court is yet to be disposed of.
Finally, yet to be disposed of. That
Then-
is the interim prayer.
May I please, Your Lordship?
Lordship, I have not completed, Lordship.
I shall wait.
Lordship, kindly peruse the last, the order against which we have approached before this honorable court. Page 477 of the CRP.
Yes.
In this order, Lordship, the learned trial court stated, may I read the whole order, Lordship?
Not necessary.
From bottom, second paragraph. I have gone through the affidavit of assets and liabilities submitted by both the parties. During interrogation with the parties, it is revealed that the petitioner is an employee of Government of Assam working as staff nurse in District Hospital, Sonapur, earns rupees 37,000 so-and-so per month, and the opposite party is working in AITC so-and-so, earning rupees 87,120 per month. It is also revealed from the petition and written statement that the petitioner has been residing separately since 16/1/2024. Admitted fact, Lordships. Considering all aspects, in my view, an amount of rupees 10,000 only can be paid by the opposite party as interim maintenance to the petitioner and her minor daughter from the date of this order till the disposal of the case. Accordingly, so-and-so has been allowed. Now, Lordship, the learned trial court stated that I have gone through the affidavit of assets and liabilities. If that is true, then nothing has been stated. What about the expenses of the educational expenses of the child and the rent which has been paying by the petitioner? So 10,000 amount, 87,000 is the salary of this father, husband, and admitted fact, petitioner is working. We have not suppressed the fact, but the educational expenses of the child, that aspect has not been considered in this order. So we are before this court, and our interim prayer was to 35,000. She is studying in faculty. Admitted fact, there are educational expenses. They were residing in rented house amounting to rupees 15,000 per month. That is also admitted fact, matter of record.
No, that's all right, madam. You see, this civil revision petition is directed against an interim order, right?
Yes, sir.
Usually against interim order, civil revision petition is not admitted, but it is admitted on the ground that the learned family court, principal judge family court, while passing the impugn order, has ignored the direction issued by the Supreme Court.
Yes, sir.
Therefore, it was admitted. But the issue raised by you now, that has to be taken care of at the final hearing by the principal judge family court.
Then, Lordship, till then, what will be the, how the expenses of the child?
No. Admittedly, you are working as a staff nurse.
Yes.
Your
I am
income is
working.
37,000.
Yes, I am working. Whether this fact will
That will be determined by the
the
trial court.
benefit this respondent from his responsibility towards the expenses of the minor child. Lordship, that is the issue.
Lordship, may I?
Mm.
Lordship, the wife in this case is already getting 54.2% of what the husband is earning, your Lordship. This that cannot be ignored, that the law has been laid down for the wives who are unable to maintain themselves.
Mm.
So the right of sustenance is a fundamental right, Your Honor, but then that comes for the wives who cannot maintain themselves. Yes, if she comes for the daughter, that is another case. But then, yes, Your Lordship, I would like to place a judgment where it is stated that it was a 2000.
Lordship, I am before
Let
this
me
court.
finish. I'm waiting for
The
it.
amount
Please,
is
let me
not
finish.
Please sit down.
reasonable.
Please sit down. Let her complete.
This is not a per equilibrium, by the honorable apex court has stated that the maintenance of the child is a duty of both husband and wife, Your Lordship. So, yes, the father and mother both, Your Lordship. Furthermore, Your Honor, in the Bible, Rajneesh versus Neha, it has been stated that extravagant, just in order to take out more money, extravagant educational expenses cannot be shown just to take out more money, Your Honor. Furthermore, Your Honor, the only order they have affixed here, annexure, is of 27/5 of 2025, Your Honor, wherever it has been stated that the maintenance amount is to be given from the date of order. After that, if they have submitted, filed any petition, the copy of the petition has not been served upon me, sending for the respondent, Your Honor. There has not been argued that even though if the trial court below has passed any such order, that has.
It shall be heard by the division bench except where the Chief Justice otherwise directs. PIL, habeas corpus application, application relating to external, relating to deportation, and any application which a single judge may refer to the Chief Justice for placing it before the division bench having regard to the importance and complexity of the case, my lord. Writ petitions in which constitutional validity of the act, rules, or any provisions thereof have been challenged. So my humble submission, my lord, this should have been heard by the division bench, my lord. And second difficulty, my lord, we are facing in implementing this order is this, my lord. In 2022, my lord, this Department of Social Welfare was bifurcated and two departments were created, my lord, out of the bifurcation. So this one is, it happened in 2022 before passing of this order by this, by your lordship, my lord. Now, the new departments is the one department is Women
No,
and Child
madam, you
Development
see,
Department and Social, the
no,
second
no.
is,
Madam, you
Madam.
see, at the time of hearing of this writ petition, the departments are represented by the
my
standing
lord,
council.
my lord, my lord.
So it was not brought on the,
My
not
lord.
before, brought to the notice of this court. Had it
Actually,
been
my
the
lord,
case,
I find, my lord, there was one argument was made by the council appearing there then, that the department has already been bifurcated. But what will be the difficulty that was not pointed out to the court. But fact remains, my lord, this was the fact remains that the departments were bifurcated before the passing of this order, and therefore it was an error apparent on the record, face of record, my lord, which requires interference. And then, my lord, there's this High Court rules also do not permit, my lord, these matters to be heard by the single judge.
yes, yes. In fact, the counsel for the respondent has conceded to the pair made by the petitioner.
Now, my lord, we cannot amend the rules, ma'am. There are two departments, and this is not our, the Social Justice Department has not made any new rule for, my lord, of their own. So therefore, my lord, we cannot now go and amend the rules, which actually will be in the arena of Women and Child Development Department. So this is the practical difficulty faced by the department. In that view
So,
of the.
madam, you see,
My lord,
the judgment was passed by this court on 15/7/2025.
my lord.
When did you file this application?
This application is filed, my lord,
On 6th of December 2025. Then what is the period of limitation for filing a review petition? 30 days?
my lord.
Is there any application for condonation of the delay?
Don't think so. I don't think so.
No. Why should not we dismiss this petition with cost? Hmm?
Next, submit one thing. Regarding my learned submission with regard to the matter to be heard by the honorable division bench.
Hmm.
It is in fact referred by the division bench to the single bench. By order dated 37/2022, my lord, it was listed before the petition was listed before the division bench, and the division bench was not inclined to take up the matter because it is not a 309 rule. That is the reason, my lord. It's an order, executive order, and executive order has to be decided by the
Single
bench. That's why it is remanded back to single bench, my lord.
Okay. That order is with you.
That order is online order, my lord. 37/2022 passed in WPC, my lord, 4850/2022.
Hmm.
It is listed before the division bench, my lord. And thereafter it is listed before the single bench. Proceed for that. WPC. And with regard to my second submission, that the department is bifurcated. That is already known to, they have brought instructions, my lord. During the proceedings of the writ petition, my lord, they have brought instructions. Had there been a difficulty in bringing the instruction on account of bifurcation, they should not have brought this the instructions, my lord. That's because they have brought the instructions before this honorable court on behalf of the respondents with addressing the issues of the case. Now they will turn up and cannot say, my lord, that we are not in a position to implement this order. They could not have brought the instruction at that point of time.
Lordship, let it come a day after. I'll take instruction. I may withdraw this one.
Day after tomorrow. Day after tomorrow. Heard Ms. Saparvati, learned counsel for the petitioner, and also heard Mr. P. Purkesto, learned counsel for the respondent. Recess and list the matter in the column admission hearing in the first week of April. First week of April.
My urgency on my part, because my lord, the process has been stalled and the petitioner is going to one of the.
No, there is no stay order.
There is no stay order, but they are not implementing. We have filed a contempt case in the name of dependency of this review petition. They are not implementing the order, my lord. That is the reason. Any day for the first week?
First week.
I have no objection.
No, I have a bench at Itanagar from 16.
Okay.
So only in the first week of April.
First of April.
36. Delay of 137 days, my lord. At this stage, notice may be issued, my lord.
Heard Mr. A. H. M. R. Chaudhary, learned counsel for the applicant. This application under Section 5 of the Limitation Act is preferred by the applicant for condonation of delay of 176 days in preferring connected review petition. Let notice be issued to the respondents returnable in 4 weeks. Step by speed post and also by usual process within a week from today, list of the 4 weeks.
Lordship, the appellant and the main, the respondent, the prime defendant number one, they have come to a mutual agreement, Lordship, and settle the issue between them. They are the
So, yeah,
brothers,
by
Lordship.
this application, you want to withdraw the RSA.
RSA, Lordship.
Okay.
On the terms, already I have annexed the
You are
agreement.
for the appellant.
I'm for the appellant, Lordship.
Okay. Heard, Mr.
As to the Lordship.
As Sutradhar, learned counsel for the applicant, struck appellant. This application is filed by the appellant for according permission to withdraw RSA number 147 of 2024. Within bracket Gopal Borkotoki and Nandan Borkotoki and others. On the ground that the matter has been settled by the parties outside the court. Amicably settled and compromised by the parties outside the court. Mr. Sutradhar, learned counsel for the applicant, submits that since the matter has been settled between the parties, right? Is there any agreement?
Yes, Lordship. Page 11 start,
As per the agreement,
and the terms and condition is at page 14, Lordship.
agreement dated 9th of October 2025. And also in view of the terms and conditions set out in
Page 14. It
In-
start from page 13, Lordship, below. And the terms and condition is page 14, Lordship.
the said agreement, he submits that the appellant may be permitted to withdraw this appeal. Para, accordingly, taking note of the submission of Mr. Sutradhar, learned counsel for the applicant, RSA number 147 of 2024, stands dispose of on withdrawal. On withdrawal. In terms of above this, I stands closed.
Obliged.
For admission, item number 10.
Order শেষ হইল?
Yeah, please, your lordship.
Yes.
Lordship, the defendants in the suit, my lord, have been debarred from filing their written statement, as well as, my lord, their written objection in the injunction application missed their case on account of the fact that, my lord, 90 days has already expired. Against that order, my lord, debarring the defendants, my lord, who are the civil division petitioners out here, my lord, this revision application.
So what is the ground?
Ground, my lord, is that, my lord, there were earlier set of counsels were engaged, my lord, by the defendants. Now they filed an application, my lord, before the honorable trial court on the first date, my lord, that they want some time to file the written statement. On the next date, my lord, they again filed another application, my lord, seeking time, as well as also filing an application parallelly, my lord, raising the issue of maintainability. But nonetheless, my lord, the law is very clear, whatever it is, my lord, and they had also filed a petition, my lord, for keeping the filing of WS in abeyance till disposal of the, my lord, preliminary issue. Now the law is, my lord, well settled that within 90 days one has to file it. Now thereafter, when these orders came to be passed, if lordship may be pleased to come to page number 64, my lord, for a moment, my lord.
No, you first show me the impugn order.
Yes, at page 64.
64.
64. The order sheet starts from page 62.
Mm.
If lordship may be pleased to see page 62, my lord, this is the first order. I have annexed, my lord, the entire order sheet. Till, my lord, the
No,
impugn order.
no, you come to impugn order first.
Yes, definitely, my lord, at page 64.
Mm.
parties are represented, the defendant by filing petition number so and so has prayed to keep the filing of WS in the suit till disposal of another application which has already been filed, praying for framing of preliminary issues regarding maintainability of the suits. Heard both sides. It is revealed that the stipulated time period for filing WS in this suit by the present defendant is already over. As such, prayer made in petition number so and so is rejected and filing of WS by the defendant is closed. However, the defendant shall have liberty to cross-examine the plaintiff's witnesses at relevant time. Also seen the petition number so and so filed by the defendant under order 14 rule 2B of the CPC praying for framing of preliminary issues regarding maintainability of the suit. Plaintiff side has already received. Then my lord, fixing 27/1/2023 for objection. Then 20.
So you were aggrieved by rejecting your petition for keeping what you have mentioned here.
Rejection of the petition, my lord, for keeping.
Keep the filing of WS in the suit till disposal of another application. Where is the provision?
Provision is clear, my lord. Within 90 days from the date of receipt of summons, one has to file the written statement. Keeping the issue of maintainability open. Now, therefore, thereafter, my lord, in the miss case also similar order has been passed. If lordship may be pleased to come to page 70.
No. Let us not go to the order passed in the miss case since this is the impugned order.
Yes. The miss case order has also been impugned here. On the same date, my lord, in the miss case also, my lord, the defendants have been debarred from filing the written objection, my lord. And there was an injunction order. That lordship will find it page 73, my lord, with all respect. Page 73, parties are represented. OP by filing petition number 395522 has prayed for adjournment for filing written objection. In this case, peruse the case record referring the order passed in the main suit. Prayer for adjournment made today by OP is rejected and filing of written objection by the OP is closed. However, the OP shall have the liberty to take part in hearing of the case. On the last occasion, my lord, if lordship may be pleased to peruse the last order passed by this honorable court in the present, my lord, revision proceedings. My lord, my learned colleague has, my lord, submitted that they will not be filing any objection. And my lord, this is a clear case, my lord, where the earlier set of councils who were engaged, my lord, the defendant, that is the Assam State Transport Corporation.
So
they
you have no objection in.
I have objection, my lord. You are not filing written objection because it's a civil division application, my lord. Here, my lord is deciding whether the learned trial court exceeded the jurisdiction or there was any jurisdictional error in the impugned order.
Yes.
And my lord, if my lord kindly takes up their pleadings made in the application at page 15 onwards, my lord, that is paragraph 19 onwards, the only ground is that the alia council did not pursue the matter properly. But that does not mean that the order was by the learned court below suffers from very irregularity, my lord. And my lord is exercising jurisdiction under 227 and not 226, my lord. It is supervisory jurisdiction, my lord. They could have very well on the next day, like an application order 9 rule 7, my lord, what we used to do, my lord. We would file an application stating the facts, the reasons why we could not file a written statement along with the written statement, and if the court rejects their prayer, then and then only they ought to have approached this honorable court, not straight away, my lord. They could have very well filed an application stating the reasons there, why they could not file the written statement within the statutory period of 90 days. They could have very well done that, my lord, but they have not done it. They straightway approached this honorable court, my lord, and possibly order and looks at them is clear in this regard, my lord.
Oh, that's all right.
So, my lord,
But the provision is directory.
Yes,
Have to be directory.
Directory, but they have to assign good reasons before the trial court.
Yes.
If trial court rejects, then question of 227 would come, my lord.
Okay, let us do one thing. You go and file an application there stating the grounds. And then the trial court shall consider the same in accordance with law, mainly keeping in mind the decision laid down by Honorable Supreme Court in the case of that Salem Advocate Bar Association and also Koilas versus Nanko.
Koilas Nanko is clear.
Yes.
My lord, then we may have to file, my lord, it will amount to filing of a review application, my lord. Because, my lord, this order has already been passed. And if we file any application, my lord, before the learned trial court for reviewing this order, it will be a regular review application. We have chosen not to file any review application, but to approach this honorable court. And this honorable court has the power, my lord, maybe, my lord, some cost may be imposed, my lord, and then allow it. Because at the end of the day, they will not be prejudiced. And we will have the opportunity to file a written statement and written objection, and thereby contesting the suit. At the end of the day, my lord, whether justice has been done, my lord, under 227, of course, power is limited. I may not, my lord, make that kind of technical submissions. But at the same time, this honorable court has the power under 227. Relegating
No,
the power,
that's all right. You see,
because, my lord,
to interfere with the order of the trial court, you have to demonstrate that the trial court has exceeded its jurisdiction or committed any material irregularity while deciding the application.
that is true, but here, my
But
lord,
here you
yes,
say there is no
yes,
ground.
that is not the ground. That is not the, admittedly, I have to be fair, my lord. I have to be fair. Because nonetheless, my lord, because only because of the default committed by the engaged counsels, my lord, even they kept quiet, my lord, after so many times, my lord, for a prolonged period.
No,
And
no, Mr. Proposer, you see, you have not filed an application before the court for assigning the reason and to accept your WS.
Exactly.
yes, even that was not filed in the later date also.
Now, let there be direction of this court for filing such an application before the trial court. And then the trial court shall consider the same in the light of the observation made by the Supreme Court in those two cases.
That is true, but my lord, whether the trial court will, that would amount, my lord, in my, of course, in my respectful submission, my lord, to filing, it would tantamount, my lord, it would give a, my lord, color to such application as if that is a review application, because we will have to
No,
agitate, my lord.
not review application because you have not filed such an application there.
No, we have not filed, but if we ought to file
No,
any
no,
such
no,
application, it will be in the nature of review application, my lord.
No.
Because there is no specific provisions under, my lord, the code, my lord. Order 9, Rule 7 is on a different footing, my lord. Because it is, my lord, setting aside ex parte, my lord. Now, here is a case, my lord, where it is not ex parte, my lord, it is still inter parte, my lord. It is still inter parte, but we have been debarred from filing our pleadings only to that extent, my lord. So if we file the pleadings and the case proceeds, my lord, thereafter, my lord, they will not be prejudiced, my lord, and the ends of justice would be met. And for any default, my lord, for on the face of the record, my lord, since we have come at a belated stage, lordship can very well, my lord.
You file an application along with the WS before the learned trial court, citing the reason for which you could not file a written statement within 90 days.
If that liberty is almost, if that liberty is granted by this honorable court, my lord, definitely will. But then again, my lord, in my, if on a my lord, technical view of the matter, my lord, it may amount to, my lord.
No. That cannot amount to filing review petition. So in fact, you have not submitted your written statement.
Absolutely.
And you have not made any pair for accepting your written statement thereafter.
Yes. I cannot travel beyond the records, my lord. What is done by the earlier set of councils, my lord, it is very much there, explicit, my lord, apparent before your lordship, my lord.
Okay, you file an application there. We dispose of this petition. Within a
Application,
period
my
of
lord,
2 weeks.
my lord,
Within a period of 2 weeks, you file it there.
my lord, can it be 3 weeks, my lord, with all respect, my lord, 3 weeks.
Okay, 3 weeks.
And lordship may be pleased to fix a date, my lord, when the parties will appear, my lord, and file a written statement.
Because the written statement, what may not be there, my lord, at this application.
No, along with a written statement.
Along with
They
the
will file an application assigning the reason for failing to file the written statement within 90 days, along with the written statement.
Yes, along with the written statement. And my lord, in the Miss Day case pertaining to, my lord, the injunction, there also we will have to file a.
My lord, may influence.
No. Whenever they have to file such an application, written statement must be there.
That is there.
That is there.
That is there. They may or may not.
Pardon?
They may or may not, my lord. At first, what times they file the application, if it is allowed, then they file the registry.
No. Along with the application. Along with the application. Yes, next item.
Item 11. My lord, then we may be, my lord, permitted to file.
When the
as-
next date is fixed there,
Next, that is not, because a record has already come, my lord.
record has.
Yes, LCR has come, my lord.
Why the record was called for?
Can records.
Scan records.
Original
that-
record is there.
Original record is there, my lord, yes, but then, my lord, that suit has been stayed, my lord.
Okay. Within 3 weeks.
3 weeks, my lord, can it be, my lord, if lordship pleases, my lord, can it be, my lord, on 23rd of, my lord, 24th of April, my lord,
Okay.
24th of April, my lord, 24th of April. My lord, we will be-
You have to file application in both the matter.
yes, my lord, in the main suit as well as in the Miss J case, my lord. The main suit and Miss J case numbers are mentioned in the application, my lord. I'm so deeply obliged.
May it please your lordship an application under section 24 of CPC
Mhm.
for transfer two cases, lordship, which are pending before the Honorable Principal Judge Family Court Guwahati Kamrup, because the petitioner wife has been residing since 2021 due to the domestic violence as well as dowry. Even the wife petitioner purchased a Maruti van for him, even though he abused, tortured, and she has been compelled to leave the matrimonial home on 6/9/2021. Hence, the respondent husband filed two cases, lordship. These two cases are pending before the Honorable Principal Judge Family Court Kamrup, lordship. One restitution case, lordship, FCC Bill 466 of 2023, and another guardianship case 32 oblique
No,
2020.
now where the cases are pending?
Lordship, in the Honorable Principal Judge Family Court, Kamrup at Guwahati,
Where the
the-
said cases are to be transferred?
transferred to Dorong, lordship, Mongoldoy Dorong.
Dorong.
The petitioner wife has been residing in her paternal house, lordship,
At Dorong.
since 2021. Lordship, in prior portion, lordship, that FC civil case number 466 of 2023 for restitution, and another guardianship case
Okay.
32 of 2023.
Okay, we are disposing of this.
Lordship, highly obliged, lordship, highly obliged.
Next item.
Item 14. Item 14.
Please, your lordship. My lord, I have brought us honorable apex court suggestions, my lord,
Yes.
and that is Union of India versus Ram Saran, my lord, in paragraph 7 and 10 and 14 discuss on this point, my lord. Where there is a specific provision is there, my lord, inherent power cannot invoke by the court, my lord. Paragraph 7, my lord. And same judgment relied, the judgment I have placed already in lordship. Para 7. Para 7, contention number 4, my lord. The court itself is the ground taken by the appellant that the court itself has inherent power to aid legal representative to do full justice to the party. Findings. We may say at once that there is no force in the 4th point. The court is not to invoke its inherent powers under section 150.
No, whether this was the issue before this court.
My lord, since my lord, trial court order 1 rule 10 petition allowed, my lord.
Let notice go. Heard Mr. Dekar, learned counsel for the petitioner. In this petition under Article 227 of the Constitution of India, the petitioner has challenged the order dated 23rd 12th 2025, passed by the learned trial court.
Yes, my lord.
In title suit number. No, in Ms. J case number 144 of 2023, arising out of title suit number 95 of 2017. It is to be noted here that by the impugn order dated so the learned tribunal, no, sorry, trial court has allowed the petition number 106/7 file under order 1 rule 10 dated section 151 CPC. For implement of the implement of
Respondents, so
implement of the
respondent 1 and 2.
respondents. Oh, respondent number 1 and 2.
The legal
in
heirs of
the
respondent
title suit.
plaintiff.
Number 95 of 2017. Where is the petition and the documents plus on record? Let notice be issued to the respondents, returnable in 4 weeks. Step be taken by speed post and also by usual
Yes,
process, which I will come to the list after 4 weeks.
My lord, my praying for interim, otherwise, my lord, if this petition allowed in continue, so my till returnable date, my lord,
No.
let them come, my lord, till returnable date.
Let
I
the
pray.
other side appear, we will consider.
Till
the
returnable
pair.
date, otherwise, my lord.
No, on next date we will consider it. We'll hear the other side only, then we will pass the order.
Then, my lord, then will, in this measure, as a wrong procedure, court will proceed, my lord. So I am praying for till returnable date, otherwise, my lord,
Interim pair of the petitioner will be considered on next date.
oblige, my lord.
Timing item number 8.
May I please, your lordship?
Yes.
In the petition, somehow some delay has been mentioned in paragraph 6, lordship earlier read, and this, even the Supreme Court, this court also stated, even amendment petition solely on the ground of delay, court should not dismiss the amendment petition, lordship. May I place the Life Insurance Corporation of India, lordship, judgment of 2022 of the Honorable Supreme Court of India, and our High Court is also, lordship, Ghanshyam Sharma, that is to 7 TJ.
That is there. My question is,
And paragraph 6, has been itself stated, lordship, in the petition.
no. My question was the due diligence. Where in which
Due
paragraph of
diligence
the
was there
petition
or
you
not?
have explained it?
Explain that paragraph 6, lordship, somehow stated fully
No. See, paragraph number 6 is the explanation for filing the petition,
filing.
not explaining the delay.
But lordship, itself explain the delay, lordship. Paragraph 6, that petition is itself explain the delay and demonstrate that the amendment is
No,
crucial
without any ground, how can you explain it?
and the due diligence as per order 6, lordship, but it's a continuous proceeding. And lordship, may I relied upon the decisions of the Honorable FS Court that
No,
Life Insurance Corporation.
whether the proviso
But here is the,
proviso of order 6 rule 17 is
But
dealt with by
lordship
the
kindly,
Supreme Court in this
may I
case.
relied upon the decision of the Honorable Supreme Court also, lordship.
No, that's all right.
That, but
Whether the
here is the
proviso,
trial court, lordship, has not said. Trial court said that I diverted.
no, my question is whether the Supreme Court in this case, LIC,
LIC.
dealt with that issue, that proviso,
That issue not been dealt with,
then
but here
to do-
is the
to do
case, every
ignore it.
amendment, lordship, here is the every amendment.
no. So do we ignore it,
Proviso. But that proviso trial court not, that finding is there, lordship, there.
maybe even then,
Even lordship, this point, lordships, the
Hmm?
tomorrow is the date, lordship. In the meantime,
No,
some
maybe.
steps in the some or within a week.
maybe. You are not answering
That
the,
proceeding on that point, lordship, trial has been commenced. I will place in this regard, lordship, even in spite of the some today I have not taken brought, lordship, but that was not brought by the court below.
Hmm.
The impugn finding is that only the petitioner has diverted the issue.
No,
That is
maybe
not
it
there.
may not be there in the impugn order, but
But
should we
that-
ignore the provision?
But should not be ignored, but even your
Then-
lordship is also aware of that, even trial comments, the court at any stage, even secondary stage also lordships allowing,
Yes, at any
Yes.
stage, provided.
only
you have to
provided
show
trial.
Your due
Trial
diligence.
comments means that on the issuance of notice.
Okay. Let notice go ahead, this is this.
So proceeding
Mr.
maybe,
Bormoya?
Lordships.
Sorry,
That-
no stay at this is this. In a routine manner, we will not grant any
Otherwise-
stay.
Lordship, by that case, will we continuously proceed, Lordship.
Heard, Mr. Bormoya, learned counsel for the petitioner. In this petition under Article 227 of the Constitution of India, the petitioner has challenged the order dated 22nd of January 2026, passed by the learned principal Judge Family Court Kasar Silsor in FC case number 194 of 2018 against the petition number 2923 of stroke 38 filed by the petitioner under order 6 rule 17 reduced section 151 of the Code of Civil Procedure. Notably, I impugn order dated so the learned principal Judge Family Court has rejected the prayer of the petitioner for amendment of the plaint. Whereas the petition and the grounds mentioned hearing, and also whereas the impugn order dated 22nd of January 2026. Let notice be issued to the respondent, returnable and for which step be taken by speed post and also by usual process within a week from today. Though Mr. Borhuya learned counsel for the petitioner press for staying the impugn order dated 22nd of January 2026, yet to a pointed query of this court as to whether in the petition filed before the learned principal of the Family Court, being petition number 2923/38, the petitioner has explained the due diligence in filing the said petition. Mr. Borhuya has failed to show from the petition any reason assigned by the petitioner before the learned trial court. In that view of the matter, this court is not inclined to grant any interim relief at this instance.
That Lordship,
Only
only
for weeks.
during pendency, the proceeding may kindly.
Sorry,
Otherwise, argument stage, Lordship.
sorry.
Short date,
You
next date, Lordship,
after 4 weeks,
fixing a date,
take it at
10th April. Obliging.
May it please, your Lordship. Lordship, I am before this court, my lord, challenging the
My lord, before my learned can start, my lord, as per the earlier order, last order, I have received the copy today only, my lord.
Okay. You are not
It was
prepared.
directed to be served within 2 days, but I have received it today only. May take some time to go through it, my lord. The order was not there in the served copy.
impugn order, madam,
Impugn
the order I am challenging.
Today
Otherwise,
Okay, you furnish a copy to him.
I have already furnished,
They have furnished.
Okay.
but a short date because, my lord,
Okay.
long time.
Heard Mr. Z. Pego, learned counsel for the petitioner, and also heard Mr. D.K. Sharma, learned counsel for the respondent. Mr. Sharma submits that only today, copy of the petition along with the impugn order is served upon him, and he needs some time to go through the same and press for listing the matter after a week.
My lord.
After 2
Fair.
weeks, my lord.
After 2 weeks, they are allowed recessal list the matter on 38th of March, 30th.
My lord. My lord, this I had today came up for substitution of the respondent of 5, my lord, who expired on 13/12/2024, paragraph 4, my lord. We want to substitute the name. I, paragraph 4, page 7. नाम तो है।
I to go.
I 574.
574.
my lord.
Then what about this IA number 808?
Malad, that is, I have filed, I have filed an implement application. I have a deceased, legal error of deceased as per number 5, against whom he is substituting, Malad. So because of the delay, Malad, we have.
On
filed a-
same subject matter, two IA has been filed.
Same
But
subject.
I think there I little bit defective, my lord. If you don't mind, my lord, if lordship see that name which has been they have given, may not be correct, my lord. Therefore, my lord, my I may be considered, nothing will happen, my lord. Only thing is that so far there I.
In both the IA, PRA said.
Same, my lord.
Okay.
Well, I have put some urgency, Malad. That is why I have filed an implement application today.
That is already there on board, but thing is that newly they have filed. My pay gap 4 money.
I am looking for 4, 6 and 2.
4, 6, and 2. 4, 6, 2.
4, 6 and 2.
Heard Mr. Samaria, learned counsel for the applicant, struck petitioner. And also heard Mr. Chakraborty, learned counsel for the respondent, opposite party number.
This is as per number 5, Malad.
No, in this IA, you are the,
808.
yes. No, 574. 574.
5 cents, Malad.
I have 5, my lord. Five.
You have not served copy of any?
My lord, we have sub copy now, the new set of council, my lord. Earlier, another set of council was newly engaged, my lord, both sides.
Earlier-
Furnish a copy to him,
Yes,
if
absolutely.
available. Okay.
But both are same, my lord.
No, that's all
No
right.
objection.
No objection. No objection.
That is also his prayer otherwise.
Mm. Take down. By this common order, it is proposed to dispose of IA number 574 of 2026 filed by the applicant, namely Kanti Devi, Vishwajit Ghosh, and Shamal Devi Agarwal, and also the IA number 808 filed by
Itu apni na ho. Record.
the applicant.
अपना मने नाम के दें फिर नहीं बोले Respond number 2.
Chakraborty, who are the applicant here in
But-
your IA?
In my eye, I am the petitioner, my
No,
lord.
no.
Oh.
In your IA, who are the applicant?
Mustaq Hussain, Malad. Son of, response number 5.
Mustaq Hussain. Mustaq Hussain.
मने ठीक भूल
No.
Yes. In both the application, the petitioners have applied for implement of.
My lord, respond number 5.
5. This is as per number 5.
This is respondent number, legal, implement of the legal representative of this is respondent number 5. It is submitted at the bar that this is respondent number 5 suffered demise on
13/12/2024.
13,
13/12/2024 mentioned in paragraph 4.
13/12/2024. Then as such, the legal representative of the said respondent are required to be brought on record. Brought on record. In the CRP number
220 of 25, Malad.
220 of 2025. 220 of 2025. Accordingly, taking note of the submission of learned counsel for both the parties, and also considering the facts and circumstances on the record, both the IAs then allowed. The legal heirs of this is respondent number 5 be implemented in the CRP number so and so as respondent number 51, 52, 53, and 54.
Well,
5.
I will file our amended course title, madam.
Okay. In view of the orders passed in these two IA, the petitioner in CRP number 220 of 2025 shall file amended cost title within a period of 1 week from today.
My lord, my lord, lordship, this matter may kindly posted, my lord, first week of April, my lord. In between, we file our amended cost title.
After 1 week.
1 week not possible, my lord. Why I don't know.
No, we have.
We have to first file our
Legal proceeding is being
No,
paid.
no,
Lordship, we have to file our course title. Lordship, just need 1 week time, and afterward, my lord, first week of April, my lord. Next week, I have little bit problem. Last week, my lord. First week of April.
First you file your amended cost title,
Absolutely.
thereafter we will consider, after 1 week.
After 1 week, yes. Always.
Supplementary list, item number 39.
May it please vote. While issuing notice of motion, my lord,
In this case, they have appeared for the first time. I would like to file a written objection against this application.
Mr. Kwar,
Yes, madam.
this is CRP IO.
But still, my lord, certain.
Where is the provision?
My lord, in civil division, I have a fundamental right to file an objection.
No, in
provided
civil
I-
revision, that is all right.
Yes.
This is IO.
It has been filed as a civil resident under the garb of Article 227, rate with 151(6).
Hmm.
Because
Here,
only to avoid
no,
delay, because the order which has been challenged is.
no, Mr. Kumar,
2025.
you see here, we are only examining the impugn order.
Yes, sir.
Its legality, propriety and correctness, nothing else. You cannot, your
On the
affidavit
points-
will,
On the law points, I can make my submission. There is
Yes,
no problem
yes,
in it.
yes.
But only thing is that there is suppression of certain material facts which will be relevant so far we are concerned. my lord.
yes,
That
you
has-
can point it out,
Yes.
but the question is,
After that, if your lordship feels that these are facts which has to be brought on record by filing an affidavit, then that opportunity. your lordship.
no, you say,
Yeah.
can we take note of those facts and circumstances
Yes.
while examining the legality, property and correctness of the impugn order?
No, but, let me say, for example, I'm not beginning, let me say, for example, first, madam, the petitioner who has filed this application is already married. And that fact has not been highlighted in this petition, number one. And number two, they have already received an amount of more than 32 lakhs as maintenance from one of the trial court. It has been mentioned, but those are, has to be determined in view of your lordship in case of Nehas that you can have to do all this calculation and all. Otherwise, on the law points, if my learned friend makes the submission, we will contest it, madam. But our defense is that she has already married and that's why she is not entitled to maintenance under the Hindu Adoption and Maintenance Act, madam. And secondly, on the law point is that.
No, Mr. Kaur,
Yes, madam.
he is the petitioner, so
Yes.
he has the right to begin.
Yes, well, the only
So-
thing is that I thought that maybe it should be brought in record by filing a written objection on this facts.
Is it
That I leave
necessary?
To the wisdom of this honorable court, I have no problem in arguing on the law points, madam.
I don't think he will go beyond law point.
I'll not go, my lord. Whatever facts submitted, marriage has solemnized in December 2025. 4/12/2025, this petition has been filed.
But even then, it's an
And
elementary
the
mercy to
notice-
inform this court that you
No-
are already married and settled in life.
And what is the relevancy? Decrees of 2017.
No, I can take up it.
I'm trying to, well, the defense should be of a nature of a defense, my lord, just not for my lord namesake. 2017 decree has been passed. That decree has been challenged before the High Court. High Court has dismissed, went to the, my lord, Supreme Court. Supreme Court also dismissed. Execution case was filed. There he is given an undertaking, I'll be paying the amount.
No.
But no, I'll point out from the record while I'm submitting, at least that is not there, that without the record I'm submitting ever. Now, thereafter he did not pay. Court passes an order directing him to pay. Then he abandoned, my lord, the proceeding. In the meantime, he retired. We have filed an application that his retiremental dues are there. So therefore,
the Oil India Limited may be directed to retain the decretal amount till disposal of the the execution case. Now the trial court dismissed the petition, saying that under section 60G, pensionary benefit cannot be attached. But without going into the particular provision, though it has recited the provision, but what is the purport of the provision that has not gone into, nor even called for any report from the Oil India Limited, whether he is entitled to the pension, whether there is any pensionary benefit, what kind of pensionary benefit. Well, 60G provides for family pension. It doesn't say of the pension. And without calling for the report, without that petition has been dismissed. Then we filed an application because she was a minor. The mother is also deserted by the husband. Petitioner is the daughter of the private respondent number 1. They intended to come to a high court, but apprehending that money may flew, they have filed another application that the money is going to the HDFC bank account of the respondent number 1. So at least bank may be directed to retain the decretal amount. Now court passes an order saying that already that pair was earlier rejected. So therefore, this cannot be entertained. However, directed the Oil India Limited to retain the decretal amount, which is not the pensionary benefit, as well as provident fund. Initially, provident fund was not there. Then this order has been passed. And the report has come. From the report, Oil India Limited has submitted a report. Therefrom, it is clearly appears there is no family pension at all. If your lordship looks into the section 60G, it is only family pension that to be notified by the central government or the state government. But here it is not the case. Now, provident fund amount, all right, even if the court did not say that provident fund would not be attached, then also other provision of the section 60 said provident fund, if it is notified, it cannot be attached under that section. But then so far as pension part is concerned, there is a pension is personal, not the family pension. So therefore, without application of mine, without going into the law, there was the illegality committed by the trial court. So therefore, those two orders are liable to be set aside. Let's find the report your lordship will kindly see.
Mrs. Soikia, but the learned trial court, executing court has directed to retain the decretal amount to the Oil India Limited.
First petition was dismissed, saying that attachment of retirement benefit pension under section 60G cannot be attached. So petition is dismissed. Subsequently, I filed an application saying that the amount is going to the bank, is lying in the bank. But the Supreme Court is very clear. This provision would be applicable even if, so far as present case is concerned, this is not applicable because this is not a family pension. Even if it is applicable, the moment the amount reaches the hands of the employee, it loses the character of the pensionary benefit or retirement benefit or gratuity. It is the money in the hands of the person concerned. So that's why way back in 1978, this has been clear.
No. Then the court directed the Oil India Limited to retain the decretal amount.
Decretal amount and call for a report.
Okay.
I had filed my first application, that was rejected, saying that section 60G, nothing can be done. Then secondly, I have filed that the amount is going to the is lying in the bank. So you direct the bank to hold the amount for satisfaction of the decree. I have also filed an application calling for a report from the Oil India Limited to submit the details, the pensionary benefit before the court. Now, so far as second petition is concerned, that has been dismissed, saying that similar petition was already dismissed. So far as this third petition is concerned, calling for the report, there the court has called for a report and in the meantime directed the Oil India Limited to retain the pensionary benefit and also included the provident fund amount. Now that report has come. The final order has not passed as yet. But since the already both the petitions have been rejected, the court cannot grant me the amount because as it appears, your lordship will kindly see, they are saying.
Is it your assumption that the court will not allow your pair?
No, because decree cannot be, already twice it has been rejected.
Mm.
It is only calling for a report.
No, yes.
Yes.
Now on the report, no order has been passed by the executing court.
Court has passed directing them to furnish a report.
Mm.
So report has been passed.
Mm.
So purpose of the petition satisfied.
Mm. No, no order has been passed.
No order has been passed.
So
Court cannot.
how the cause of action arises?
No, I am challenging the earlier order. I am challenging the order dated 5/6/2024, first rejection.
Mm.
I am challenging the second rejection,
Mm.
not the calling for the report.
No, that's all right. In the third
What-
petition filed by you,
Is calling for the
trial
report.
court has, executing court has called for a report and also directed the Oil India Limited to retain the amount. Then your third petition is yet to be disposed of.
Well, that is only with regard to the calling for the report.
Mm.
It is only calling for the report, my lord. Now the report has been submitted.
Mm.
Since the earlier orders, I am challenging the earlier orders by which it has been said that pensionary benefit, retiremental benefit cannot be attached. That
No, you first show me the third petition here.
Lordship.
Is it part of the record?
Lordship.
Page number
My lord, at page 83. my lord.
83.
Prayer is at page 85. This was basically filed for the purpose of the second petition. But second petition has been dismissed.
No, here also there is pair.
Submit a report before the honorable court regarding the process
To
of
hold the
status-
payment of whole or part of the outstanding digital amount of rupees.
To hold the payment of whole or
32
part of the outstanding digital amount 32 from the part of the so-and-so, my lord.
Mm.
But this is basically call for a report and to hold during the submission of the report. The first prayer is to submit the report. And this is though drafting is in a way it ought to have been interim or something like that, but if or intermediary order, this second report is like this, my lord. Now, even if it is lordship say that this has been hold, now there is no petition pending
Mm.
for satisfying the decree, except the original application execution case.
Mm.
Because by the first order rejected, second order to the bank that has been rejected. Now this is a petition only calling for the report and to hold the amount.
Mm.
But then decree has to be satisfied.
Mm.
There is no such petition as such pending except the original one, my lord.
Mm.
Now they have submitted a report.
Mm.
Now your report, your lordship will kindly see the report.
Mm.
Is
Page
at
number?
page 93.
Yes.
This is the report, my lord. Provident fund 55 lakhs so and so. The first order did not say about the provident fund,
Mm.
but the second order included provident fund.
Mm.
It has the effect of reviewing the order of the passed by the earlier court, my lord.
Mm.
Because initially it was only under section 60G. Then second year lordship will see the gratuity. Yes, gratuity cannot be paid attached under the section 60G.
Mm.
Leave encashment, it is not within the purview of 60G. Then Oil India Pension Fund, they have said not yet, annuity has not submitted, so it is not. This is also cannot be, this is also not family pension. This is only employees provident fund, a scheme, employees provident fund. Then Oil India Superannuation Benefit Scheme, This is also not a family pension. My lord, that amount is, my lord, 23 lakhs and so is there. Then, my lord, paragraph 3, it says, it is respectfully submitted that this petitioner has meanwhile forwarded the proposal regarding payment of superannuation benefit to the judgment debtor to their corporate office at Delhi from necessary approval of competent authority for release of the benefit. Well, this is not the family pension as well, my lord. Now, while, my lord, moving, my lord, here on the last occasion, the Oil India Limited has appeared and they have said the entire amount has been paid except the amount of this leave encashment. Except the amount, page 93. Perhaps it is not recorded, but Oil India is there. Huh?
Okay.
Rest
So
all
what
paid.
was the direction of the court? Direction of the court. So retain the decretal amount. Then how you have released this amount?
Which are not part of
Hmm.
87 of our starter of channel.
Hmm.
My lord, the 80.
Also dedicated to all the amendments up to 32,25,000 from the part of provisions and benefits which are not part of pension, definitely and provision fund in part order of this court.
Yes. 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 So how they can release the pension, my lord, if it is, my lord, said, my lord, family pension, how, my lord, this mentioning is that, my lord, the part of the pension gratuity, my lord. But the earlier order, your lordship will face section 60, he says it is family pension, not the pension. May I take your lordship to the, my lord, section 60G, my lord.
So this is one of the impugn order?
Yes, my lord. 5.2 is one of the impugn order.
And the second one is?
This is the second one. The first one is at page 76.
76.
Operative part, page 78.
Yes.
It is mentioned family pension. Your lordship has seen, my lord, page 78. He has recited, London Court, my lord, has recited service family pension fund notified in the official gazette by the central government or the state government, my lord. This family pension, my lord, the very word denotes, my lord, it is the benefit to the family members of the employee, deceased employee. But the pension is payable while the service is, my lord, while the service holder is alive and he retires or resigns. That is pension, my lord. But this is family pension. Under section 54 of the, my lord, CCS rules, my lord, reference is, my lord, for the purpose of family pension. The family pension only payable to the family members of the, my lord, deceased. After the, my lord, death of the, my lord, employee concerned. And this section 30, my lord, 61G, my lord, clearly provides that the family pension. Now this report does not, my lord, specify any of the, my lord, component as being a family pension. But now they said they have released and 19 lakhs is only there because it is a leave encashment. And I am challenging, my lord, so far as the, my lord, earlier orders, my lord, if this goes, my lord, it is up to the Oil India Limited how to return the money and the satisfaction of the, my lord, decree, because there is a, my lord, the order itself is says that what is not the pension, because there, my lord,
No,
your lordship,
Mr. Soikia,
lordship.
whether Oil India Limited was a party in the earlier suit?
No. No.
Then?
No, my lord, as because Oil India Limited is the employer, so we have filed an application saying that the retirement benefit dues are there. And it is not the case that Oil India Limited did not pay. In fact, my lord, the mother has also obtained a decree from the court after due contest maintenance. That was, my lord, not satisfied. The warrant, my lord, this warrant was issued to the, my lord, my lord, Oil India Limited to, my lord, satisfy the decree. Now he files a petition before this court for change of the bank account, etc. The mother came to know, intervenes in the matter, and there he points out that the decree has to be satisfied by the Oil India Limited. The court, there is no objection from any side that the pension is not payable. So these are all matters of record.
No, Mr. Soikia, you see, since the decree was not against the Oil India Limited, can we ask them to satisfy the decree now?
No, my lord, they have to hold it, my lord. The direction is there. So therefore, direction is there. The moment they said that 19,000 is only there, that is a contempt. I am not going into that. I am, my lord, here the orders which are impugned are the 5/6/2024 and, my lord, 5/2/2024. Whether the trial court was, my lord, justified in passing the order, whether it has exceeded its jurisdiction, whether, my lord, it is an abuse of the process of the court. On this angle, Lordship will scrutinize these two orders. And if your Lordship finds that these orders are bad, the consequence will follow, my lord.
Mr. Kumar,
Yes, my lord.
why don't you settle the matter once for all?
I think it should be, after hearing my, it should be referred to the mediation, the father and daughter can sit. The only she is after the money. So whatever amount they can negotiate.
No,
between
no,
themselves.
decretal amount. You pay the decretal amount.
No, my lord, I cannot give that assurance. my lord,
No,
because-
no, you are not supposed to give the assurance.
But I think the best way, my lord, since this is, I'm not going to the technicalities because I have just been to show that this 63 covers all this amount. So it has been rightly held by the trial court. And so for the second petition, your lordship has.
No,
seen-
no, 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 forget about the provision.
So your lordship.
The matter is between husband and wife and daughter.
Yes, my lord.
Settle the matter, settle the dispute once for all.
Your lordship will
You satisfy the decree.
Well, your lordship will refer the matter to the trial court or they can refer to the mediation. Let this 3 persons sit because now the girl is married. And your lordship knows that under the Hindu adoption, only till the time she cannot.
No,
maintain
that's all right. There is no
something.
dispute about it.
So. I
But the
have no
decree
objection,
is
my
a
lord.
must prior to the
Decree of
marriage of
70.
the
Already, my
daughter.
lord, I have not challenged it. They have deducted 32 lakhs and odd from my provision fund. I did not object. I could have challenged it because they could not have done it from my provision fund because there is a statutory bar also. I did not do it because I was not able to pay it because of the complaint of my wife.
No,
Of a
this is,
false case, I
my lord,
was
I'll just
arrested
intervene because this was a consent order. He was a party while
No,
this
no,
court
no,
has,
no.
while this court has, my lord, directed, my lord.
and if you want to
My lord,
contest
no,
on
no,
marriage, then
that
it
is also
a-
there
then
in.
we'll object on marriage.
No, but
But
that does
I'm
not
saying
mean,
that if the matter is
that does not mean you'll misguide the court. The order is here. I can refer. His appearance I can refer. Where
learned
this
friend will
court has
kindly
said.
hear, my lord, instead of fighting it over us between the council, let the matter be referred to the mediation of the High Court. Your lordship will give the time frame to settle the matter. I believe, my lord, now much water because they are away from 2013. And because of the complaint of the wife, I have lost my job. I got arrested in a 48 hours detention and that too, your lordship, the High Court has set aside the my termination order, everything. But even then, by the time I was superannuated from 2013, because of this litigation, the person who was supposed to be the GM of the All India, he lost everything in life. So I think that for the last time, if my learned friend agrees, then it can be referred to the mediation in the High Court. I will ask him to come wherever he is and let them resolve it. Madam. I'll also.
No, I have no
The
problem in referring the matter to the mediation.
There's
But
no
the question is
Satisfaction of the decree.
satisfaction of the decree.
My lord, provided they give us an undertaking that they will give a quietus to everything because now she is married till the time. Because even under this, again, I have to say it on the matter. If they agree to give a quietus to the matter, everything in life, from 2013, all of them have been separate. I was not even invited to my daughter's wedding and all, then leaving it all aside. If they want to give it a quietus, we can agree on an amount and to give.
No, agree on amount means decretal amount.
decretal amount.
Decretal amount, they have to contest there, this litigation will continue for another 5 years, it will not be.
That's what been doing,
In
madam.
2013, they have been pursuing to me to get my job terminated and all.
No, Mr. Kumar, you see, what is the scope for mediation on the decree?
No,
The question is, you have to satisfy it.
no, your lordship will see the order which is under challenge, my lord.
No, decree is already there.
But even the
That decree has not been challenged.
No, but your lordship will see
It has
the
attained finality.
within your lordship will see the order.
Decree was challenged by him before the High Court. That was dismissed. It was again taken to the Supreme Court. Supreme Court also dismissed.
Even today.
So it attained finality.
Yes, my lord. Your lordship may kindly see the order dated, my lord, 18-1, my lord, at page 33. And details are given.
If you want to argue on merit, then I cannot agree to that.
No, Mr. Kumar, you see, if the Supreme Court has also dismissed your petition, then what left to it?
Well, your lordship will
You
see-
have to satisfy the
Yes,
decree.
your lordship will now see what I have to pay.
The decretal amount.
Your lordship will see the order. Your lordship will have a look at the order.
Page number?
But that's not. Let me record the first one. I'm just showing the first one. 28, so page 28 is the operative order. Your lordship got the order? The respondent so and so is directed to pay rupees 5 lakh as interim relief from the period between 8/7/2013 up to 10/5/2016. My lord, your lordship will see what has happened. Pay 5 lakhs, this I have to pay towards the expenses of Shivangini's marriage ceremony. 5 lakhs, 10 lakhs. Then the respondent Deepak Kumar is directed to pay rupees 25,000 per month as maintenance to Shivangini from the date of this order. From the date of this order till what date, my lord? For that your lordship has to look at section 20 of the.
That is till date of marriage. There's no dispute.
Or not, now it has been, your lordship will kindly look at section 20 of the Hindu Adoption and Maintenance Act, my lord. Section 20. Your lordship got section 20. Subject to the provisions of this section, a Hindu is bound, I being a Hindu, during his or her lifetime to maintain his or her legitimate or illegitimate children and his or her estate or informed parents. A legitimate or illegitimate child may claim maintenance from his or her father or mother so long as the child is a minor. Number one. Second, my lord, the obligation of a person to maintain his or her estate or informed parent or a daughter who is unmarried extends insofar as the parent or the unmarried daughter, as the case may be, is unable to maintain himself or herself out of his or her own earnings or other property. She started working in a job. I think she is paying her IT returns and all. She is an MBA. So I did not pay till date or till the time of the marriage. Till the time when she was unable to maintain herself. Let them tell how much money I have to pay. Then I can communicate to my client that this is the amount. If you pay it, we can settle it for once and for all. Now this will end. The mother's petition is now pending before the High Court in regard to that matter. Because all this has happened because even after I could have paid all this money. But what has happened, my lord, but because of the complaint of my wife, I lost my job. I became penniless.
No, that's all right. It is no one will be benefited by opening the closed chapter.
Yes, madam.
You see, this 5 lakhs and 5 lakhs, 10 lakhs.
That too, yeah, I see. Madam,
And
10 lakhs I
this
can-
25,000 with area.
Till the time she was able to not maintain herself. Now she had started walking long back. She is an MBA. And now she is married. I don't know the dates
my lord,
because it has not been mentioned. in the
My lord, these
petition.
are all these statements are in there. Let him produce the documents that I was earning, my lord.
But
They all
it is
become that.
you have to
But-
give your assets and liabilities
lord,
to take claim
My lord,
maintenance.
so far as the law I know, my lord, whoever asserts, he is to prove. My lord.
No, Lord,
He is asserting, my lord.
family
He knows
matters-
everything what he is saying.
in
I have
family
been
matters-
working, I have been submitting IT returns, all these things. Only to my lord misguide this honorable court, my lord. Let him submit any documents, my return, everything, my lord, or employment.
know,
He
you
is
have to
asserting
submit.
that.
It is within
He
your
is not
knowledge.
contesting the my lord, before the my lord, trial court with regard to the execution. He is not appearing. The thing is going my lord, expertise.
My lord, I did not advise
Yes.
my learned friend how to pursue an execution case in a trial court, my lord.
I am saying that it is proceeding expertise. I am not suggesting him that you should go and appear. But I am saying you have not participated
Your
there.
lordship will see the
There-
second,
there-
what was their second petition, your lordship will see, which my learned friend has referred, instead of.
No, you tell me,
Yes.
the learned executing court in the order dated 5/6/2024
Yes, my lord.
in paragraph number 2 has recorded a
Page
finding that
number-
decretal
Your
amount
lordship
is 30 lakhs 75,000 by deducting the same from the benefit dues of the judgment debtor. Oh, you pay this amount?
Well, 10 lakhs, 5 lakhs to 10 lakhs is okay, madam, but the rest amount your lordship will, at least.
No, there is already one finding.
Your lordship will see. Your lordship will look into that petition at page 73.
Yes. 30 lakhs 75,000.
Your lordship will see paragraph number 30.
Yes.
This is the petition filed by them, your lordship, look at paragraph number 30. That is therefore humbly prayed before this honorable court to issue direction to all liaison to satisfy the decretal amount by deducting the same from the dues of the judgment debtor lying with the employer oil and to pay to the decree holder the following amount. Interim relief from the period from 8/7/2000 up to 10/5/2000 is 5 lakhs. Towards the expenses of marriage ceremony, 5 lakhs. This is 5/10, which I've already referred. Then this maintenance of so and so till so and so is 20 lakhs 70,000. Till date.
Till date, that is the date of filing of the petition, 24, 2025. Yes. And the order has been passed 32 is of 2025.
But there is no statement in the petition or anywhere that from which date she started earning. From which day from which she has started earning, I don't have the liability to pay her. And even in this case also, your lordship, see the.
So what material the learned courts below have ignored?
Yes, Lordship. Lordship may kindly come to page number 95, which is the construction permission. The site map
95.
95. Here it shows that the width of the plot of land is 35 feet plus. Width of the plot of land. And on the very next page, here lies the home plan on page number 96. In the home plan, they have approved a home which is 30.2 feet plus. 10 feet plus 10.2 feet plus another 10 feet. So this is an illegality of the rule which is stated on the last page of the which is the inquiry report, where the government has made a rule that minimum of 1.5 meters has to be left out on both sides. So total 3 meters has to be left. 3 meters amounts to almost 10 feet. And they have approved of a home where they have only left 5 feet on the side. So the construction permission is illegal.
So those documents were exhibited before the
Yes, Lordship,
trial.
yes, they are part of the record.
Heard, Mr. Your name, please?
P. Borborua.
P. Barbara, learned counsel for the petitioner. And also heard, no, sorry. This appeal under section 10, no, sorry, 100 of the Code of Civil Procedure is preferred by the appellant challenging the judgment dated 14/11/2025 and the decree dated 26/11/2025 passed by the learned civil judge senior division Gulagat in title appeal number 1 of 2025. It is to be noted here that by the impugned judgment and decree dated so and so, the learned civil judge senior division Gulagat, put in bracket hereinafter the first appellate court has upheld the judgment and decree judgment dated 29/10/2024 and the decree dated 12/11/2024 passed by the learned civil judge junior division number 1 Gulagat, Assam in title suit number 1 of 2021. It is to be noted here that by impugned the by judgment and decree dated so and so, the learned civil judge junior division number 1 Gulagat has decreed the suit.
Sorry, Lordship?
Trial court has decreed the suit.
Yes. they
Where
have-
is the judgment?
The trial court judgment starts on page number 17.
17.
Yes, Lordship.
No, trial court has dismissed the suit.
Yes, and so did the appellate court.
Dismissed the suit filed by the appellant hearing. Where is the memo of appeal? Grounds mentioned therein. And also also peruse the impugned judgment and decree passed by the learned first appellate court and also the judgment and decree passed by the learned trial court. This second appeal is admitted on the following substantial question of law. Number, whether the judgment and decree of the learned appellate court is vitiated suffers from perversity for being passed, ignoring the material evidence on record. Para. The court may also consider framing of any other substantial question of law if found necessary at the time of hearing after notifying both the parties. Race shall call for the record from the learned courts below, list the matter, issue notice, returnable in 4 weeks, step by speed post and also by usual process within a week from today. List after 4 weeks. Call for record.
Deeply obliged.